judicial prayer for listing of a matter for day after tomorrow. It is filed on 17th October. It is not listed.
Motion.
Motion.
That is the lawsuit. I am also praying for listing of an WBC for motion lawsuit.
For
Motion lawsuit.
motion, fresh matter.
Yes, lawsuit.
All right. Friday.
May I please, Your Lordship?
Mm.
This matter, I am praying for listing this matter for hearing, my lord. On last occasion, the matter came before this court and already been heard and fixed the matter on 3rd September. But in the meantime, the BTC council has
Let
changed.
it come for orders on Monday.
It has already been heard, my lord.
No, but it can't be listed for hearing like that. You have to bring it for orders.
Yes,
We'll have to
right.
fix a date
Yes,
on Monday.
must be.
Yes.
Right, Nikhil. But I beg to mention item number 660 of supplementary list.
60.
Yes, ma'am.
Yes.
I'm praying for some accommodation today as I have some personal difficulty.
Item 60 on the request made by Mr. J. Patwari stands deferred to be listed again after 2 weeks.
Lordship,
With the consent of other side, I beg to mention item number 27, 28, and 29 of the daily list. Lordship, seeking for an adjournment.
Consent obtained.
Lordship,
My lord, I am for a petitioner, my lord. I am praying for a date, my lord. Though you are not unemployed.
27, 8, 9, 27, 28, 29. On the request made by the council for PNRD, matter stands deferred to be listed again. On these are for what? Reply not filed.
Reply not filed.
Nineteenth November.
Right. Little of the.
Of
May I please, Your Lordship, with the consent of the respondents, I beg to mention item number 46. Lordship, today we have some difficulty on our part. Lordship, may I pray to take up this matter in second week of November, Lordship?
In November,
November, second week of.
second week of November. All right. 19 November. Yes.
My lord, I beg to mention for listing, petition, my lord, admission matter, your lord.
Admission matter listing.
My lord.
This on on 10th.
My, and two similar matter, my lord, and this two similar matter,
Why did you say pray for a matter? Two matters
my lord,
for admission.
for admission.
What are the subject matters?
My lord, promotion of,
Both matters.
my lord, for this.
All right. 10th.
Wait, please, just a
God
moment.
bless you, Lord.
My lord, three similar writ petition, my lord, file on my lord 2210, my lord, and pay for listing for motion, my lord, on Monday,
Monday.
my lord.
You can come on Friday if you want. Friday?
My lord, my
Yeah.
obliged.
Lordship, I am mentioning item number 22 for adjournment.
22.
Lordship,
Yes. On whose behalf?
it's Buragahan. He is out of station, Lordship.
Item 22 stands deferred on the request made by the council for the applicant in the IA. Matter stands, matters to be listed after 2 weeks.
May I, Lordship, I pray for listing of the petition next week for admission, my lord.
Admission.
My lord.
12th.
Okay. Another, my lord, one week petition which I filed on Friday, last Friday, for motion. I'm praying for listing on Friday, my lord. New motion.
Fresh matter.
Fresh matter, my lord.
All right, Friday.
May please, Your Lordship. Lordship, I beg to mention item number 50 of the daily list, my lord. But I am seeking accommodation for the day, my lord. I have to obtain instruction, my lord, whether anything survives in this writ petition.
Item 50.
Item 50, my.
You want time for?
I have to obtain instruction, my lord, whether this petition.
1 week. Item 50 stands deferred to be listed after 1 week at the request made by the council for the petitioner.
Obliged.
Yes.
May it please, Your Lordship, Lordship, I beg to mention item number 16 of today's daily list.
Item number
16 on 6.
16. Yes.
Lordship, our leading counsel, Mr. A. Hussain is out of station. So may
Item
the-
16 on the request made on behalf of the council for petitioner stands deferred to be listed after 2 weeks.
May it
Must
please,
oblige.
Lordship, I beg to mention item number 13,
I pray that I may be permitted to withdraw this content petition as
Item
the
13.
1-3. In the order has already been complied with.
We'll close it. Let the matter be called up.
Lordship.
We'll close it.
Lordship, with a consent from the other side, I beg to mention item number 51. Lordship, we will file a reply to their affidavit in opposition, Lordship. That this matter will be listed after 1 week, Lordship.
51, and
Yes,
the
Lordship.
request made by the council for petitioner stands deferred to be listed after 2 weeks.
Much more.
Yes.
May praise the Lordship. Lordship, I beg to mention for listing, your Lordship. The matter pertains to area salary of the petitioner, Lordship. Kindly list the matter after 1 week.
For admission,
Yes,
12th November.
obligation.
May please your lordship, I beg to mention for listing. Lordship, there are two red petition.
For admission,
Yes, lordship.
12th November.
Lordship, I beg to mention item number 57, supplementary list. I am appearing on behalf of BK Das. The petition does not want to continue or pursue the
It
matter.
is already listed for that. You be around. You remain. Yes.
Made will Lordship, my lord. Item 22, the bank has filed the counter, my lord. We want to
It
file.
has already been adjourned.
That's all, my lord.
22.
State Bank of India.
Some I is filed, Kamal Nath.
Yes.
It has been adjourned on by the bank, council for the
Oh.
bank.
Oh, I didn't know, I was on.
As per instructions received, the council for the petitioner submits that the petitioner does not wish to press the petition any further. Accordingly, same stands dismissed or withdrawn.
I'm for 1 and 2, Lord.
With liberty and interim orders, if any stand vacated, pending ayes are also dismissed. Mr. N. Upadhyay appears for
1 and 2.
respondent 1 and 2, and
PTC appearing on behalf.
name MS so and so appearing on behalf of 3 and 4.
3 and 4, Lord.
3 and 4.
Lord.
4.
Account general is not here.
They are not a party here.
Account general is not there, Lord.
Accountant general is not a party.
Not a partner. Oblige, Lord.
Dismissed.
It can be closed, my lord. Petitioner gets daily, my lord.
Counsel for the petitioner submits that the petition does not, petitioner does not wish to press the petition any further accordingly. Writ petition stands closed as not pressed, dismissed as not pressed. Interim orders, if any, stand vacated, pending ayes are also dismissed. Mr. T.C. Sutia, London Senior Government Advocate, appears on behalf of respondent number 1, 2, 3. MS, so on behalf of R.K. Talukdar, respondent 4. Yes.
Oblige, my lord.
Lordship, in this case, instruction was sought for from the government. From the government.
What is your prayer for
Your
the
Lordship,
direction that it should be implemented?
Lordship, it should be implemented and we have changed the entire selection process, Your Lordship. That's why, Your Lordship, you don't have the names and addresses of all the candidates, Your Lordship, who were selected. But
Yes, who's for the respondents?
on last occasion, Your
State
Lordship,
government for respondents 1 to 4.
on last occasion, Your Lordship, Sarma Pathak was there.
We'll issue notice then.
Lordship, Lordship.
Mr. S. Bhattakur, learned counsel for the petitioner, issue notice returnable 4 weeks. Mr. P.C. Sutia, additional senior government advocate, represents appearing for respondents number 1, 2, 3, 4. And Mr. Dr. appears for respondent number 5. Five. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Respondents will complete their instructions and file necessary affidavit by the returnable date.
There is an I, Your Lordship, for increment of 8 candidates, selected candidates. Your Lordship.
There's no IA, I think.
Lost. We have filed, your lordship, probably it has not been done.
লিস্টত দেখাইছে in the IA, is there any objection or we issue notice here?
Objection of. They have not.
Let us, better to issue notice heard in the IA, heard. Council for parties, this is a 226-3, all for implement.
For implement, your lordship.
It's filed under 226-3.
Lordship, so sorry, your lordship, I did not look into it.
Heard council for parties. Probably the last IA you might have filed was under 226-3.
There's coffee, problem with coffee pasting. Extremely sorry, your lordship, I
You
apologize.
don't have to be sorry.
Yes, lordship.
You're entitled to file it. We want to know whether it is
Lordship.
under 226-3 or
Lordship.
not. Heard council for parties issue notice. Returnable 4 weeks. Mr. Supriya appears for opposite party 1, 2, 3, 4. Mr. P.P. Dr. for respondent number 5. Whose names do you seek to include?
Lordship from your lordship.
Where are the names?
Lordship, names your lordship. I have. Page your lordship.
Opposite parties.
10 your lordship.
Opposite parties who are the individuals who are sought to be implemented as opposite parties are named in paragraph 4 on the said IA. Let the applicant take steps by speed post
Lord.
within 1 week from today. Better be listed along with the writ petition after the return.
Deeply. observed.
With pleasure, lordship.
Yes.
Last occasion, government advocate
Lordship,
took time for instruction. Mm.
Friday, Lordship.
Friday,
Yes.
Monday,
Monday,
give you
Lordship, Lordship,
buffer
Lordship,
days.
Lordship, Lordship.
Monday.
That's status of the proceeding department.
Obliged.
M.S.K. Devi for the petitioner, Mr. J.K. Goswami, additional senior government advocate. The praise for further time as agreed to by both parties.
Obliged.
Matter pertains to compassionate appointment. In this case, my lord.
We'll issue notice here.
Only issue is this, my lord, he was a railway employee, my lord. Whether this honorable court will have jurisdiction, that is an issue, my lord.
I don't.
Because on earlier occasion, my lord, he approached Kate.
Cat.
Yes,
Hmm.
Kate will have the jurisdiction, my lord.
You heard it. We are not, we are only issuing notice. You raise the point of.
My lord, that will be kept open.
My lord, that this is a alternative remedy and also
What
the-
alternative remedy?
my humble submission, my lord. My clients, my lord, social and financial condition. So as to, it is hard
It's
convenient.
only a question of choice of the forum, that's all.
Yes, my lord.
The choice of the forum which is prescribed. It heard the learned counsel for parties. Petitioner is claiming, what are you claiming?
My lord, compassionate appointment.
Compassionate appointment in the railways, Indian Railways, as her late husband, who was an employee,
No, my not late husband, late mother-in-law.
late mother-in-law
Yes.
was an employee and who subsequently died in harness. The respondents have not yielded to the request made by the petitioner and therefore the petition has been filed. Where Mr. Odhikari, learned CGC, at the outset had raised the objection with regard to the question of maintainability of the writ petition. He submits that In earlier occasion, the writ petitioner had approached the Central Administrative Tribunal.
bench.
CAT.
CAT.
He therefore submits that the writ petition is not maintainable and the proper forum is the CAT. Learned Counsel will address the court on the question of maintainability before notice is issued in the matter. Since although notices are not issued, extra copies be furnished to the learned CGC to obtain required instructions in the matter, list again after 2 weeks. Notice issue for a matter.
Wait, Mr. Lordship. In this case, the petitioner for lordship is unmarried daughter whose father and mother both were government student by law. She has been paid
Out is on the same posting.
no, my lord.
Then
She has been paid for the, my lord, family pension in respect of her father's service, but in respect of her mother's service, my lord, she has not been paid the family pension. My lord, by the improved communication at page 30, a clarification has been made by the Administrative Reforms Training Pension Public Grievance Department that she is not entitled to the 2 family pensions. I'm challenging that communication my lord, at page 30. My lord. Last but one paragraph, my lord. As such, the question of entitlement of 2 family pension to an unmarried dependent daughter does not arise. Rule does not say that they are not entitled.
let heard learned counsel for parties issue notice returned to the floor. Mr. 8 October T appears for respondent
3 and 6, Lordship.
3 and 6.
And for lordship, if they're not.
Who is for 1 and 2? 1 and 2.
RM Das, Standing Council of Social Justice and Employment.
Where is Mr. Das? Have you served copies? No.
Yes, my lord.
Standing Council for Social Justice and Empowerment represents respondents 1 and 2. And MS so-and-so appears for respondent number 4. And MS Port Harcourt appears for respondent number 5. Since the respondents are represented, notices are waived, extra copies will be furnished. Within a period of 1 week from today, the respondents, more particularly the Accountant General, will complete their instructions and file necessary affidavit with regard to the objections raised in the communication dated 2010-2023. No, sorry.
2010, my lord. 2010-2023.
Who's for respondent 6?
6, I am not.
So the respondent number 6 will more particularly respondent number 6 will complete our instructions and apprise the court in respect of the communication dated so and so addressed to the office of the Accountant General. List again after the returnable dates. Extra copies lower. Extra copies lower.
My lord, this is the second round of litigation, my lord. Earlier, your lordships disposed of the petition by order at page 59, my lord.
Same posting.
Same posting, you must.
No, what has happened now?
My lord, after passing this order, my lord, the petitioner also lordship filed a representation before the authority. Authority, by the impugned order at page 73, has rejected this claim.
Which is the impugned order?
Page 73, my lord.
73.
My lord. Annexure 26, page 73.
It's a detailed speaking order, my lord.
They say that there is no post in Nalbari, so he cannot be accommodated.
You issue notice, eh?
Yes, my lord, notice may be
But
issued.
my lord, the order at page 76,
Hmm.
another person has been posted at Nalbari,
No, but it will have to be examined. This is the third round,
second round. my lord.
second round.
And my lord, the speaking order says that not only that the post is not available in Nalbari, because the post where the petitioner is posted, my lord, their persons are not available, which would cause, my lord, health services in that area, my lord. That is also a factor, my lord.
My lord,
Your petitioner is an employee of health department
Yes, my lord.
and his spouse,
Education
If-
department.
My lord, is teacher in education department.
you are posted where?
I am posted at Nagaon, my lord. My wife is posted at my lord, Nalbari.
So you want to be posted at Nalbari or you want your wife to be posted at Nagaon?
I want to be posted at Nalbari or any other nearby place, my lord. I'm not saying that I should be posted at Nalbari only, my lord. I should be posted any other nearby place, my lord. So that I can stay with my family, my lord.
1 hour, 2 hours? No, 2.5 hours maximum. Nalbari and
Nagaon, this is not 2.5 hours, my lord. From Guwahati, it takes.
no, if you want, you can within 6 hours you will not reach. That's a different issue. But ordinarily, how far is Nagaon and
From Nalbari.
one Guwahati, one side is Nagaon, other side is Nalbari. Both are equidistant.
There is a post lying vacant at Sipajar, my lord. Sipajar, that post also, my lord, I could have been accommodated, my lord.
They have already considered it.
That aspect
What
was not
what malafide intention do you impute in
My
the
lord, the office
what
memorandum-
malice?
office memorandum says, if the, my lord, post is not available in the particular place, the person should be posted any other nearby place. And my lord, the persons at, my lord, page 76,
Hmm.
he has been transferred and posted at Nalbari. Why not the petitioner, my lord? And I was not, when my attachment order was recalled, nobody was transferred from, my lord.
No,
my-
but it cannot be that this person will have to be sent out and then you'll
No,
be
no, I'm
placed.
not saying that. I am not
Ah.
saying that, my lord, but
Ah.
they have, I am just annexing this.
Now you find out and tell me how many posts in around Nalbari are available.
That's
You find out.
My lord, that is not only the issue, because the place where the petitioner is posted. So we want a person over there. And in the speaking order also, my lord, it has been observed that, however, if the petitioner is able to arrange a mutual transfer with another eligible MPW from Nalbari district, the same may be considered. Because we want a person over there also, my lord.
My lord,
So it has been
No,
done
no,
in.
you have come before the court challenging this particular order. That order has to be shown to be illegal,
Yes, my lord.
arbitrary,
Yes, my lord.
Yes.
exercise of power.
My friend's submission is that, my lord, a person is required at Nagaon. But while I was, my lord, returned back to Nagaon, my lord, no one was transferred from Nagaon. The post was lying vacant.
Yes,
That
that was lying vacant.
that
That's why he has been.
administrative exigencies are things which are best left to the departments.
Yes, that can. But
Isn't it?
my lord,
Unless you show that no, there is a policy and this policy has been deliberately not complied with as far
my
as
lord,
you are
the
concerned.
policy at page 49. Policy at page 49. My lord, page 50 is the, my lord, second illustration, where one spouse belongs to one state service and the other spouse belongs to the another state service. The spouse with the longer service at a station may apply for appropriate cadre controlling authority, and the said authority may post the said officer to the station of the other spouse, or if there is no post in the station, to the nearest station where a post may be available. And my lord, this issue has been decided by the Honorable Court also in another litigation, my lord, wherein this Honorable Court has held that, my lord, they should be posted in the same station or any other nearby place, my lord. As the posters at Sipaja.
When you get instructions, Mr. Bora,
Notice may be issued, my lord, I will file affidavit, my lord.
no, you first get instructions.
My lord, if we go by this notification, my lord, this office memorandum, it says, my lord, the spouse with the longer service at a station may apply. So in this case, the wife is serving as assistant teacher since the year 2011 in the same station. So she has to apply, my lord. If we go by the strictly as per this office memorandum, my lord. Because she has been serving as assistant teacher since
You
the.
get instructions. let
Yes,
us
my
see.
lord.
Third, counsel for parties. Petitioner is agreed that his prayer for transfer and posting at a place where his spouse is posted, namely the district of Nalbari, has not been exceeded ACC in spite of posts, suitable posts available under the health department in and around the district of Nalbari. Counsel for the petitioner has referred to which memorandum or notification, page number 52,
Page, my lord,
52,
49, my lord.
49.
Page
Is
49.
referred to and relied upon the office memorandum dated 21st of May 1987, issued by the Department of Personnel, within bracket capital B, Government of Assam. It is submitted that although the policy of transfer and posting of husband and wife who are both employee under the state of Assam is already in place, the same has not been followed by the department in spite of representations stopped being agreed. Petitioner, the representation of the petitioner is rejected by which order?
By order at page, my lord, 73, my lord, 19/9/2025.
By the order dated 19/9/2025 by the health department being agreed, the present petition has been filed. At this stage, Mr. D.P. Bora, Standing Counsel Health, is permitted to complete his instructions and apprise the court if the grievances of the petitioner can be redressed by the department. This matter be listed after 3 weeks. Although notices are not issued, extra copies be furnished within a period of 1 week from today.
The date we fixed, my lord. What date we fixed?
After 3 weeks on 21st
My lord.
November.
Obliged, lord.
Obliged.
My lord, the petitioners before your lordship applied for the post of constable, my lord, under Home Department of Assam. And they were, my lord, ultimately passed all the level. And finally, they also appeared for Baibavosi, my lord. And last their call card, my lord, page 130, my lord. And final result is also published, my lord, declared in the online, my lord. But petitioner are not getting their result, my lord. Only they are shown, my lord, they are failed, my lord.
Mr. Sutia, any?
No, my lord, the notice may issue because, my lord, lordship kindly see page 107. Some criteria is there. And physical standard test, there is no marks. Only physical efficiency test, there is a 40 marks. And at least is prepared on the basis of marks obtained by the candidates.
Heard
And
counsel for parties, you should notice it and Mr. T.C. Sutia, learned additional senior government advocate, hears and accepts notice on behalf of all the respondents. As such notices are waived, however, extra copies be furnished within a period of 1 week from today.
Obliged.
Yes, accordingly. Meet Visual Lordship. Lordship, this is pertaining to Lordship non-payment of compassionate family pension under 142A as well as non-payment family pension law. My husband expired on 29/7/2021. While in service, madam. Thereafter, I have applied for retirement benefits, including family pension, DCRG, GPF. Your husband served for how many years or months? My lord, he was going to retire on, my lord, 29/8/2023. And, but he died, my lord, during service on 29/7/2021. 2 years left, my lord. Who's for, which department is this pension is there? Health department. Health. Have you sent the pension papers?
Pension paper has been sent according to petitioner statement.
No. Get your instructions?
Yes, Lordship.
Let your instructions
Yes,
come.
next week, any day.
Next week, okay. Heard Mr. Dr. Leonard Counsel for the petitioners. MS S. Sharma appearing for the health department. MS. You are appearing for
1. Respondent number 1, M. Kalita.
M. Kolita, appears for respondent number 1. And Accountant General, anybody? Anyone for Accountant General?
No, yes.
Mr. R.K. Talukdar appears for Accountant General. Petitioner is agreed that the family pension, compassionate family pension, receivable by the petitioner in respect of services rendered by her husband who expired while in service.
Yes, it
Has not been released by the department. So counsel for the petitioner submits that the Assam Services Pension Amendment Rules 2022, Rule 142-A mandates the issuance of compassionate family pension to the family of the deceased government servant. So, let the respondents complete their instructions. All the notices are not issued, extra copies be furnished within the course of this week. Matter be listed again on 10th.
Lord.
10th.
deeply obliged.
Wait, please, my lord. Here, my lord, the petitioner is aggrieved by a transfer order primarily on 2 grounds, my lord. There is a violation of the transfer policy of the bank, and secondly on medical ground. Lordship, if I may take your lordship first to the transfer policy that I have annexed at page 38. Lordship has got it, my lord, page 38. Lordship, kindly take note, my lord. Lordship, may kindly turn to page 42 of the policy. Common guidelines for transfer. Clause number 4. Female officers, employees shall be tried to transfer as far as possible to the nearby places, stations, regions in case of their transfer to a place where their husband, parents are stationed, or as near as possible to the place or vice versa. Based on availability of vacancies and administrative convenience. However, this will not be applicable on promotion. 1, my lord. Next, lordship may kindly turn to the next page. Transfer rules of officers, page 43. Lordship may kindly turn to clause number 2. May I read, my lord?
No officer shall remain posted in the same capacity position for more than 3 years. Normally, officers will not be rotated, transferred before completion of 1 year. Once a person is transferred from one place to another, before completion of 1 year, that person will not be transferred. Next, my lord, clause number 6. After posting to tenures, that is 6 years in one region, officer will be transferred to other region. Head office will be considered as a region for this purpose. My lord, what happens, my lord, if from one region to another, a person can be transferred only after 6 years of service in a particular region. Now, lordship will kindly turn to the facts of the case, my lord.
Yes.
My lord, the petitioner, she joined in service on 13th of July 2013 as office assistant multipurpose in the respondent bank. And she was joined at Golaghat branch, posted at Golaghat branch. Subsequently, in the month of December 16, she was transferred from Golaghat branch to Narikalguri branch. And thereafter, by page number 16, that is an order of internal office order, 29 May 2020, the petitioner was promoted to the post of assistant manager. Lordship has got in mind. On promotion, she was transferred from Narikalguri branch to Guwahati branch. That is from Golaghat region to Guwahati region, my lord. That release order will find, lordship will find at page number 17, the next page. Posting order number 34, 2020-21, dated 5/8/2020. My lord, on 7/8/2020, the petitioner was released from Narikalguri branch by the branch manager to join in the Guwahati branch. Accordingly, the petitioner joined in Guwahati branch on 10/8/2020. Kindly take note of this date, my lord. 10/8/2020, she joined. Subsequently, my lord, by the next page, page 13, page 18, my lord, from Guwahati branch, the petitioner was transferred to Guwahati regional office. By transfer posting order, reference will be found at the top, my lord. Transfer posting order number 5, dated 29/4/2025. That order is of 5/5/2025, my lord. With reference to the above transfer posting order number so and so, you are released from Guwahati branch today on 5/5/2025 at 6 p.m. for joining Guwahati regional office immediately. On the next date, my lord, that is 6/5/2025, the petitioner joined in Guwahati regional branch. Now, my lord, lordship will kindly turn to the impugned transfer order, which your lordship will find at page 21. Here, my lord, the petitioner's name appears at serial number 4. This is a common transfer order, and all transfers are unilateral, my lord. No person has been posted in place of the petitioner. Sarmistha Bora, regional office, Guwahati, Guwahati to Ganapufuri branch, to the region Golaghat. Now, my lord, as per the transfer policy, on 5/5/2025, she was transferred from Guwahati branch to Guwahati regional office. And as per transfer policy, she should not be transferred within 1 year. That violation is there, my lord. And secondly, if lordship takes note of the date of joining in Guwahati region, she has been transferred within 5 years, my lord. Whereas as per guidelines, inter-regional transfer is not to be given effect to prior to 6 years. And additionally, my lord, health on these issues are also there. Lordship will kindly turn to page 22. My lord, the husband of the petitioner is a severe cardiac patient. And in the year 2012, he had the open heart surgery at Bangalore. And thereafter, he is on treatment. All the medical documents are also annexed, my lord. Page 22 is the discharge certificate whereby petitioner's husband open heart surgery was performed, my lord. Page 22. Lordship has got it, my lord. At that time, husband was 25 years only, my lord. At that time, open heart surgery was conducted. And page 30 is a relevantly recent medical document which shows that petitioner is still undergoing treatment for cardiology health disorder, my lord. My lord, petitioner herself is suffering from, due to health condition of the husband and other issues, my lord, she is suffering from psychological anxiety, hypertension and anxiety issues, my lord, for which she is undergoing treatment. Those documents, lordship will find it page 19 and 20. Now, lordship will kindly turn to page 20, the down below. There is a note of the doctor.
Your essential grievance is that the guidelines have been violated.
And also health issues also there, my lord.
The
Kindly
health
take
issues
note,
can be available there also.
my lord.
Health facilities are available in the place of posting.
No, my
also.
lord, it is available. Lordship, kindly take note, my lord. Kindly take note. Why I am saying, my lord.
You are posted in Golaghat.
I have been, no, I have to.
Originally?
Originally in Golaghat, then transferred to Narikol.
When were you posted?
My lord.
When were you posted in Golaghat?
Initially, in the date of joining, 13/7/2013.
So you are in the till 2020?
Till my promotion, yes.
2020?
Yes.
So that was the time your husband underwent cardiac open heart
No,
surgery?
that time the petitioner was not married with the that time the marriage was not solemnized.
All right, but to say that Golaghat doesn't have health facility.
No, my lord, kindly take note, my lord. Kindly take
Jorhat
note.
is nearby.
Yes, my lord. Kindly take note, the note, my lord. Patient needs, page 20, my lord. Patient needs to continue her treatment under medical supervision under the care of his immediate family member. What happens, my lord? Husband is a cardiac patient. Her daughter is a student of class 6, my
No,
lord.
no. Is it an indication that the patient is not available or not capable of working?
No, my lord, it is not. Anxiety is a normal problem, my lord. Otherwise,
So why is what kind of an advice is this? Medical supervision under the immediate family members.
because, my lord, for anxieties and all, normally lordship knows, my lord, when medication is granted, it is to be taken at the.
What we are trying to tell you is that this certificate is self-defeating for you.
My lord.
You are working in an organization where transfer is an incident
Yes,
of
yes,
service. Now, if you say that unless there is a supervision of the family members, your medical treatment cannot continue. Then you are exposing yourself to some restriction.
Yes, but that is there, my lord. That is there, but that is the fact has been.
Medication, periodic checkup can always be taken up.
And my lord, mother-in-law is also a cancer patient, my lord, of the petitioner who is residing with the petitioner.
Right. But what about the policy? Why have you kept transferred her?
The policy only says, my lord, that after 6 years, they have to be transferred. So that is the mandatory requirement.
So before 6 years?
Before 6 years, it can be transferred. The only
Why did you
restriction-
post her in, when was she posted in regional office?
That was in
Regional office on 5/5/2025.
And you transfer her in October?
Well, the regional office itself is also in Guwahati, Malod, and she has been in Guwahati since the year 2020. Malod, this is not a case of vindictive transfer.
Not about that. She was posted. Is the promotion, is the transfer to regional office on promotion?
No, my lord.
No.
Same cadre?
No.
Same.
So what is the fun in transferring her to one place and then sending her out of the?
Malod, along with her, Malod, other persons, 7 other persons.
We are not questioning your transfer policy. What we are saying is she was posted as what manager?
Assistant manager.
Assistant manager in the Guwahati office.
Yes.
In the same cadre, she was posted to regional office.
Yes.
Right?
Yes.
If you had a policy to transfer her to different district, you could have transferred her straight from the.
That could have been done, Malod.
That
But
could have been done.
Malod, perhaps there is a vacancy arising. There is an administrative vacancy. These are difficult to predict, Malod. These are
Get your instructions.
And my lord, one more aspect, lordship.
Yes.
Kindly take note, my lord. At petitioner applied for sick leave, right, page 36. It was approved by the assistant general manager. Lordship, kindly see the approval, my lord. Considering the medical condition and doctor's advice for rest, sick leave for the period is approved.
This is after the transfer.
My lord, after the transfer. But immediately by next page, the same authority released the petitioner from service, my lord. Who has
In view of the transfer order.
My lord?
in view of the transfer.
Yes,
order.
my lord.
Consequence. That is a natural consequence of the 1510 order. my lord.
My limited prayer at this stage is that the transfer order and the release order may be stayed, my
No,
lord.
she is on sick leave till 7/11. This matter can be taken up on Monday. I'll file my affidavit. Let this matter be decided. Every matter of transfer is now coming before your lordship's.
So therefore, be careful about the way you issue
Because
your
we have-
transfer orders.
Because if
We are not here to question your policies.
that is all right, my lord, but they come
But
up
prima
with all
facie-
sorts of my lord documents.
Huh?
Kindly see the document of the doctor, my lords. On 9th October, one document, and again after 1 week, one document. He is saying family members. Now, my lords, if she needs the supervision of the family members, a question arises. Mother-in-law is a cancer patient, husband is a heart patient. Which family member will take care, my lords? Whether she's in Guwahati or whether she's in Golaghat. My lord, these are, I will take instruction, my lord, to the, in all fairness, whether she can be accommodated in an adjacent region. No, these matters cannot be challenged like this man in this manner.
What
Even if there is a transfer this violation of the transfer policy, my lords. Law is settled.
See, the reason why people come to court is because you are unable to sort out your problems.
Lords, we
They're
try
your
to sort out
employees.
the best extent
They're
possible.
your employees.
Because they,
We are not
Company is
saying
always
that-
unhappy
We
with
are
this.
not saying that the authorities are supposed to take consent of the employees
No.
for transfer, but your policy, if you have a policy,
on
I
that
just don't have
aspect,
a
that
policy.
1 year aspect, I'll
Don't
take
have a
instruction.
policy.
I'll also take instruction on whether she can be accommodated in an adjacent region.
yes. Third counsel for parties, this writ petition is filed by the petitioner putting a challenge to the transfer order dated page number,
1510.
1510,
page number.
page number 21.
Fifteen 2025, whereby the petitioner was transferred from regional office Guwahati of the Assam Grameen Vikas Bank to Golaghat branch as a branch head.
Gonakpukhuri branch, my lord. Golaghat, under Golaghat region.
Gonakpukhuri branch under Golaghat of the in the district of Golaghat as the branch head. Petitioner, it is submitted that the petitioner earlier was posted in Golaghat and subsequently on promotion, she was transferred to the Guwahati branch by order dated 7/8/2020. And thereafter, on 5/5/2025, she was posted at the Guwahati branch, Guwahati regional office from her earlier posting, which is Guwahati branch of the Grameen Vikas Bank store. It is submitted by the learned counsel for the petitioner that these transfers are violative of the transfer policy of the bank. According to the counsel for the petitioner, these transfer policy clearly laid down that insofar as female officers are concerned, the bank authorities will attempt to transfer as far as possible to nearby places / stations / regions where their husbands or parents are stationed based on availability of vacancy and administrative convenience. Stop. It is also pointed out by the learned counsel for the petitioner that normally transfers, normally the officers shall not be rotated or transfer before completion of 1 year. Stop. It is therefore submitted that the petitioner was transferred in the month of May to the regional office in the same capacity or cadre, and now within 5 months she is again being transferred to as a branch head in Golaghat. Stop. That apart, the husband and the mother-in-law of the petitioner are suffering from various ailments and require constant medical care and supervision. Stop. The petitioner herself is also under medical treatment for anxiety and stress. So under such circumstances, the petition, it is submitted that the impugned transfer order be interfered with and the petitioner be directed, the authorities be directed to permit the petitioner to be retained in her present place of posting and only go accommodate her as per clause 4. As per the guidelines, transfer policy and guidelines. Stop. It is also submitted that where the petitioner had applied for medical leave, which was issued by the authority on 17/10. However, on 23/10, she was also released from the regional office, allowing her to join in her new place of posting. It is therefore submitted that during the pendency of the writ petition, adequate interim protection be granted. Mr. Ganguly, learned standing counsel for the bank, strongly objects to the submissions of the counsel for the petitioner. He submits that there is no infirmity in the transfer issued to the petitioner. Petitioner had been posted in Guwahati for 5 years.
Lordship. In excess of 5 years.
More than 5 years. And therefore, as per the policy itself, she was required to be transferred out. So, however, on the question of whether the petitioner can be accommodated in nearby stations.
Adjacent region. Adjacent region as per the policy.
Not adjacent, as
No,
per
the
this
policy
clause
states-
4. As per the clause 4. At page 42. As per the clause 4 of the
Because there is
transfer guidelines.
yes,
under
clause
the
4,
heading,
and also
common
there
guidelines
is
for transfer,
clause 6 at page 43.
The learned counsel,
6 markets.
6 years to mandatory.
standing counsel submits that he would like to obtain his instructions. Accordingly, let the matter be listed again on
No, Lordship will have it on Monday. Mills. I'll file my
Monday
Lordship.
Which
These
is-
are transfer matters unnecessarily pending.
on 3rd.
On 3rd, 5th is a holiday, Mills, so 3rd.
You want it on 3rd,
I want.
right? On 3rd, as agreed to.
Because in the meantime, Mills, it's not necessary to pass an interim order, Mills, because she's on sick leave till 7/11.
Till the next
Lordship may
day fixed,
consider on the
the
next
impugned transfer order and the release order, consequential release orders shall not be given effect to. Transfer order pertaining to the writ petitioner only. And the consequential release order shall not be given effect to.
Perhaps Lordship will decide that on 3rd. Mills.
3rd, we'll decide. Till then, don't give
But
effect.
till then, we cannot, Mills. We will not, she's on leave, Mills.
Whatever
that-
it may be, but that effect, don't give the effect.
My learned friend will seek time for rejoinder on that date, Mills, again.
We don't know.
File it
Problems.
tomorrow, I'll file my rejoinder day after tomorrow.
How will you
File
file?
it.
He says he's filing it by Monday. How can you file your rejoinder by tomorrow?
No, if he files the tomorrow, I'm saying that
Will you, Lordship?
there is apparent violation, my lord.
Extra copies of the writ petition be furnished during the course of the day,
Yes.
although notices are not issued in the matter. Yes.
Obliged, deeply obliged.
May I please, Lordship?
Hmm.
Lordship, in this matter, I was directed to file an affidavit in opposition, Lordship. Unfortunately, the commissioner of the Assam State Council.
was sought for, not affidavit. Instruction was sought for, my lord.
No, not affidavit. You took some time to obtain instructions.
Instruction, Lordship. Sorry, Lordship.
Oh.
Commissioner was out of the country, Lordship. Today morning, he is reached Guwahati. That's why I may be allowed to one at time. Can it be listed on 5th of November?
It's only the
7th,
17th.
Lordship.
on the request made by Mr. T. Gogoi, learned standing counsel, Assam State Housing Board.
Lordship.
Matter stands defers to be listed on 7th
7th of November.
November. Mr. Sharma appears for the writ petition.
I'm obliged.
Obliged.
56.
Please, your lordship. Your lordship had already dealt with similar matters on previous.
You
occasions.
have a copy of that order?
Yes, lordship, we have annexed to the writ petition. 256.
All right,
Two-
council for the
262.
274?
Yes, lordship.
Oh, no, sorry.
That's the
274 is
corrected
a
order.
consequential order.
Yes, lordship. The petitioner was,
We had issued a little shorter order thereafter.
yes,
Do you have a copy of that also?
yes, already annexed.
Which one?
That pages 273.
No. 273 is a continuation of the earlier order.
Yes, Lord.
But in similar matters, while issuing notice, we had issued a little shorter order.
Yes, in Moon Majumdar, your lordship had issued that.
Is it available here?
Has been annexed, Lord.
No, this is the first order. Anyway, we'll find it. Third Learned Council for the parties issued notice. Mr. D. Nath.
Well, I'm
Senior
appearing for respondent number 1.
Senior Government Advocate appears for respondent 1, Mr. B. Chaudhary for respondent numbers 2, 3, and 4. Where is that impugned order?
Lordship at annexure P1, it's dated
Page,
27/7/25
page
at
number.
page 63.
Impugned order dated number so and so dated 27/7/2025 shall not be given effect to till the next date fixed. Yet a similar orders pass to issue. They will give you a set. You see, show it to me, then you pass. Yes. Is there any date fixed here? No.
Lordship.
Extra copies to be furnished to all the
Interim-
standing councils.
Lordship.
Much obliged.
Lordship has given 4 weeks. Notice.
Where we should notice
4 weeks, my lord.
4 weeks.
4 weeks.
Yes.
Yeah.
And not to give effect to.
No. Thank you.
Dated list for orders, items 10 to 12.
Somebody informed you are in bereavement?
Yes, my lord, actually, my maternal aunt.
All right.
Yesterday.
So you want some accommodation today?
Well, today, my lord,
But I have spoken.
for
to
this case only, my lord.
Spoken to the secretary, my lord. Kindly take it up on Monday, my lord. By that time I'll get this.
Not on Monday, let it be on Friday, 7th.
7, lordship.
List on 7th. And the request made by Mr. D. Nath, Senior Government Advocate, Mr. N.K. Kolita appears for the application.
Okay.
Item 13.
It is submitted by the Learned Counsel for the petitioner that the directions contained,
In judgment
the-
dated 3/12/21,
page,
page 11.
in the order dated 3/12/2021 passed in WPC number 6375 of 2021 has since been complied with. Taking into consideration the submissions made by the counsel for the petitioner, contempt petition stands closed. Notices issued stand recalled. Disposed.
Obliged, lordship.
14.
Yes.
May it please your lordship, I'm appearing on behalf of M. Das. The Honorable Court directed.
Steps have not been taken. Steps for implement.
Yes. Impeachment petition.
Have you seen the order sheet?
The last order?
Order sheet.
No.
Yes. As per order sheet, as per office note dated 8/7/2025, steps for implement by the petitioner has not been taken. Counsel for the petitioner is permitted to take steps within 4 weeks, list after 4 weeks. You see the order sheet.
No. Lordship.
I know you have not seen it. See it now.
Order sheet?
Yes, see the order sheet, what it says. Okay? দেখুন দেখাই দিব order sheet to দেখাই দিব। Yes. Any instructions?
Well, the order has been complied with. She has been promoted, my lord.
All right.
I have the order, my lord.
Yes.
I have no instruction to that.
On 17 July 25, she was promoted.
This court by order dated 4/1/2023 passed in WPC 7730/2022 had directed, had allowed the writ petition, disposed of the writ petition with the following direction. Para 8 and 9. Since this order was not complied with, council, the writ petitioner has filed the contempt petition alleging willful disobedience of the directions contained in this order. Notices in the contempt petition were issued. Thereafter, during the pendency of the contempt petition, the petitioner's case was considered, and she was temporarily promoted to the post of accountant, Office of the Commissionerate of Food, Public Distribution, Consumer Affairs and Legal Metrology, Assam, Udubari. In pursuance to the review selection committee meeting held on 17/7/2025. The order of promotion was also issued on 17/7/2025. Copy of the said order has been placed before this court by the learned counsel representing the respondents. Stop considering that upon perusal of the said order placed before the court, and upon considering the submissions made, this court is of the view that the directions contained in the order dated so-and-so, passed in WPC so-and-so, stood complied with. Stop, therefore, the contempt petition stands closed. Accordingly, notices issued stand recalled. This court.
I'm on.
17.
May I please, Your Lordship, in this matter, my lord, I have an instruction to withdraw this matter, my lord.
Order complied with.
I have instructions that the pension has been released in favor of the first wife.
Ah,
So, my lord, and thereafter a writ petition was filed, my lord. So,
thereafter,
a writ petition was filed by the present petitioner, my lord. Direction is to release the pensions and other benefits, my lord. So if they have to challenge something, then it should be in 226 my lord petition. And so I have instruction to withdraw, my lord.
pension has been released in favor of whom?
In favor of the first wife, my lord.
Who is the first wife?
Other wife is my lord. As the Bulbuli Khatun, my lord.
Who is the first wife?
Okay, I'm sorry, my lord, I could not have that brief, my lord, because the conducting council are out of station, my lord.
Huh?
Because the conducting council is out of station, that's why brief is not with me, my lord. Bulbuli Khatun is the petitioner, he is,
So pension has been released in her name,
not in her name, in the name of the petitioner of the
writ
order.
petition,
Yes, my lord.
Nurani Khatun.
Yes, my lord. In that case, my lord, present petitioner is the respondent, my lord.
Well, you will close it in terms that
my
the
lord.
directions have been complied with.
But
Heard counsel for the petitioner. It is submitted on instructions that the directions contained in the order dated so and so. Order dated 15/3/2023, passed in WPC 7656 of 2022. Has been complied with and therefore the contempt petition. The writ petition, the petitioner does not want to pursue the matter any further. Stop. By order dated 15/3/2023, passed in WPC 7656 of 2022. The writ petition was disposed of with the following direction: para 8 and 9 and 10. In the said writ petition, present contempt petitioner was arrayed as respondent number 7. So, since the order was not complied with, the contempt petition was filed. During the pendency of the contempt petition, the respondents have complied with the directions contained in the order dated so and so, passed in WPC so and so, as extracted above. And therefore, the petitioner has been complied with as extracted above. Stop. In that view of the matter, taking into consideration the submissions made, this court is not inclined to proceed any further with the contempt proceedings. The same stands closed. Notices issued are recalled, disposed.
In this case, respondent number 1 has entered appearance, lordship, and respondent number 2, ID card has returned back. And regarding respondent number
You
3,
take fresh steps on 2.
lordship, and they are supposed to file affidavit, lordship.
Mr. R. Fugan appears for the writ petitioner. Mr. Ghosh, counsel, represents respondent number
1, lordship.
1.
2 and notice has been issued.
Who's for 2 and 3?
Lordship, for 2 also I can appear, but notice has not been served.
Hmm?
For respondent
If
number
you
2.
appear, then no notice is required. Further notice to be issued.
Okay.
Mr. Ghosh appears for respondent 1 and 2.
Yes, lordship.
Press steps on respondent 3 by registered by speed post. By speed post within 1 week from today. Matter be listed thereafter. After 4 weeks.
May please allow. My lord, I am told by my learned friend that, my lord, they have received some amount, my lord. And so for this,
Here, Lordship, they were supposed to be paid, Lordship, 6 months salary, Lordship. And Lordship, they were working under the central government scheme, Lordship. So, Lordship, we have received 17 lakhs, out of which, Lordship, 8.5 lakhs was paid in the month of March 2025. So now, Lordship, only 4 to 5 months salary is remaining. So we have received, again, Lordship, we have received the second installment of 8.5 lakhs, Lordship, which will be dispersed very soon, Lordship. So, Lordship.
Counsel for the respondent, Mr. D. Upamanyu submits that partial payment has been made to the petitioners in pursuance of the directions of the court passed by the order dated.
order dated, my lord, 3/5/24, page 36, my lord.
35. 35, Lordship.
Page 36.
3/5/2024 passed in WPC 1727 of 2024. Insofar as contemplated case number 487 of 2024 is concerned. E2 case outside key case, second case number. The counsel for the respondent therefore submits that
Second installment.
the second installment of
8.5
comprising the outstanding dues payable to the writ petition, contempt petitioners will be released within 4 weeks. Therefore,
They are
be listed
agreeable
after-
to just, my lord, release it, my lord, within 10 days also, man. I am told by.
Matter therefore be listed after, well, it will listed after 3 weeks.
Lordship.
List after 3 weeks. Mr. J.C. Bora, IPS for the writ petitioner.
My lord, as I am just told that, my lord, this may be disposed of that, my lord, they are going to comply with this order, my lord. And they have, because they
How
are.
can we close it when the order has not been complied with in full?
My lord,
You have filed the contempt petition.
Yes, my lord, they are supposed to release, my lord, by
They're
10 days.
supposed to release. If they don't release, they are exposing themselves to contempt.
Yes.
Why do you want the matter to be closed before?
Yes, that is there, my lord. But
Ah.
as per my, because my lord, there are, my lord, the employees, my lord, more than 25, my lord, in numbers, my lord. And they have not approached, my lord, for my lord, seeking this.
You get instructions from your client who has informed your client that the contempt petition should be closed. Only then the payment will be released.
No, man, that is not there, my lord.
Then there is what you submitted.
Yes, my lord. So they are agreeable, my lord, within 10 days, 10 days. So for these two petitioners are concerned, my lord.
You have approached the court. We did not invite you.
Yes, yes.
You have filed a contempt.
Yes.
Once you file a contempt, it is between the court and the contemptor.
Lordship.
You are insignificant that way.
Yes, yes.
Then, as
Well,
far as we are concerned, our orders have not been complied with.
Yes, yes.
We'll proceed in contempt.
My lord, in fact, they are seeking an order from the court that, my lord, they will be releasing this amount. So for these two petitioners are concerned, man. So they want this order, man. So that is their contention, man.
Are you representing them or you're representing your clients?
My lord, their contention, what I was told.
Their
by-
contention, they are represented by counsel, they will submit.
Yes. Yes,
Why are you submitting on their behalf?
Yes, yes.
Lordship, let it come after 3 weeks, Lordship. I'll place the instructions.
List after 3 weeks.
Highly obliged, Lordship.
Your presence is also not required.
Yes, yes, my lord.
Don't be concerned that you have to be present here. No.
Yes.
We'll ensure that our orders are complied with.
Yes, yes.
So you can devote your time to some more important matters
Lordship.
on the next date.
Deeply obliged. Highly obliged.
Your Lordship, my senior is currently engaged in another court. So if you kindly take the matter after some time.
Environment and forest. Where is the forest council? Forest. We'll call it up after a while.
Okay.
Look, it's on money. Yes.
Lordship, herein the petitioner is working as a sub-inspector under CRPF. Now, in 2019, he was deputed as junior intelligence officer under NCB, Narcotics Control Bureau, Lordship. During that time, Lordship, a case under NCB came to be registered, case number 94 of 2023. And he was part of the investigation team there in Lordship. Now, Lordship, he was repatriated to the CRPF in 2022 itself, Lordship. Now, a departmental proceeding came to be drawn, citing some lapses in the investigation, Lordship, on the part of the petitioner in that case, Lordship. Now, herein, the IA has been filed with a prayer that the special inquiry team which prepared a report basing upon which the departmental proceeding came to be initiated. In that special inquiry team, Mr. Gyaneswar Singh was the chairman, Lordship, and that same Gyaneswar Singh headed the investigation also, Lordship. So there is a biasness in this process, Lordship, wherein the SCT was prepared and basing upon that, the departmental proceeding came to be initiated against me, Lordship. Now, I am similarly placed to one Samir.
Why did you approach a Delhi High Court?
Lordship, that's not me, but one similarly placed incumbent to that of me, Lordship. That is Samir Dhyandev Wankhade, Lordship. And in his case, Lordship,
Departmental proceeding is there as and when, what is the status of the DP?
Now, my lord, what has happened, my lord, challenging that, my lord, non-supply of certain documents, my lord, he approaches honorable court in the connected date petition. My lord, now, my lord, on 6th of September, October, my lord, documents, he had sought for, my lord, 5 documents. 4 documents we have submitted to him, and the 5th documents, my lord, why we didn't, my lord, furnish, explanation has been given. Lordship, kindly have a look at this. Lordship, kindly, where is para 3? My lord, he has acknowledged the receipt of those documents also. पैसा दे दो।
Lordship.
Yes.
Yes. Now, my lord, the DP will commence. Because, my lord, that later, if your lordship wants to peruse, my lord, that is annexure 6, page 97 in the date petition. My lord, he had asked for certain documents. So, all but one has not been given. And, my lord, the explanation has also been given as to why the one document has not been given to him. Here also, my lord, we have asked him if he wants to inspect, my lord, he can inspect. The liberty has also been given to him regarding the document which has not been given to him.
Lordship, may kindly peruse the interim order once. That is at page 17 of the IA, Lordship. I have annexed it in the IA also. Here 11%.
No, what are the documents you wanted to inspect? Where is that?
The page 97 in the date petition. my lord.
So you have been given up to 5.
No, 3 and 6 are not same. So mere repetition.
So 1, 2, 4 and 5 you have given.
No, 1, 2, my lord, 4 and 5, yes. And my lord, the explanation has been given regarding my lord, serial number 3 in that letter. my lord.
So what is handing and taking report means? What is handing and taking report?
My lord, I
What does it
think-
contain?
Yes. Perhaps, my lord, it contains certain documents, my lord, while the matter was handed over to the SIT by the NCB, my lord. Because the matter was investigated by SIT, my lord. And this is not part of the departmental proceeding, my lord.
Where is the charge sheet? Memo of charges?
Lordship, it's
Page 45.
No, Lordship, may kindly go to the interim order once, Lordship. That has to be modified if this order is to sustain, Lordship. Because he is required to provide all the documents, Lordship, in terms of this interim order.
Then you file an application seeking modification of the interim order.
So far as one thing is concerned, my lord, we have complied.
How? It
Yes,
says,
yes, my lord, Lordship may
furnish
kindly-
all documents.
Lordship may kindly see, my lord, and para 8 of the order, my lord, at page
Why didn't
17.
you see the interim order?
Yes, interim order.
Ah,
Yes,
right.
page 17 in the IA.
Yes.
Operative part, my lord, para 8.
Hmm.
As an interim measure, it is provided that before proceeding with the examination of other witnesses,
Hmm.
the respondent number 7, that is the second in command, inquiry officer, 175 Battalion, CRPF Rani, now posted at 55 Battalion, shall provide all the documents to the petitioner for which he has made a request by letter dated 4/7/2023, Annexure 6, and also has gone through that. But in that letter, he has asked for 5 documents. But we have provided him.
What 5, 6
No,
documents?
Roshan, kindly come to the page 97 once again.
No, 5 documents, all right.
Yes, 5 documents.
Because
4 we
three-
have provided.
3 and 5, 3 and 6
Same,
are same.
repetition, repeat, yes.
All right.
Well, we have provided him 4, and regarding 5th one, we have given the explanation. We have asked him if he wants to inspect it,
That
he can.
explanation, you bring it by way of an application and seek modification of the interim order.
My lord, we will do that.
Are we supposed to give you legal advice? There is
sorry,
interim order.
I'm sorry, ma'am. I'm sorry. Yes, we will do that.
The IA has also been listed, Lordship. I'm really.
IA has been filed by whom?
It's filed by me, Lordship.
Ah,
Herein in this IA, I'm praying that the SCP may not be relied upon in the departmental proceeding that has been initiated against me, Lord.
what?
The report of the SCP, that is the Special Inquiry Team,
Ah.
Lordship, there.
What is your prayer in the writ petition?
But it is not there. In the main petition.
is the challenge with regard to the departmental proceeding, Lordship.
Not to the constitution of the committee.
No, my lord.
Now,
You are challenging you are making a challenge to the,
yeah, yes, Lordship, but herein I am stating certain facts which have.
then it will require amendment of the writ petition. Your basic challenge to the writ petition, if one has to go by the prayers,
Yes.
are setting aside the impugned departmental inquiry initiated.
Lordship, now I am praying, my prayer is in the IA, Lordship, my prayer is that, Lordship, the report of the special.
What are the grounds for interfering with the
Not to
departmental proceeding?
interfere with Lordship, but only not to rely upon that special inquiry team, because
What are the grounds on which you have assailed the departmental proceedings?
Lordship, the grounds, there are many, Lordship. Herein, Lordship, the departmental inquiry.
Paragraph 47.
Yes, my lord. 47.
May I read, Lordship?
This is not the ground. The prayer made in the IA is not one of the ground.
It's not there, Lordship.
Then
But what will happen, Lordship?
whatever will happen, will happen. You decide what is to be done. But on the premise of the writ petition, on the grounds which you have urged, you are asking for something more which is not a part of the writ petition.
Because.
What stops you from getting a proper amendment? If you want.
I am alleging biasness, Lordship, and it can.
We'll examine in the format, in the frame that you have put up in
In
the
the
writ
IA that
petition.
has been challenged, Lordship.
All right. We'll hear both IA and the writ petition.
Because they will proceed with
Have
the
you
departmental
completed your pleadings?
Yes, in the main case, my lord, we have
All
filed
right.
our.
We have issued notice in the IA also. If you want, you can file your objections. Heard counsel for parties pursuant to issuance of notice in the IA. The respondents are yet to, the opposite parties are yet to file their objections. You want to file any, you are praying for some time to file
Yes,
an
yes.
objection?
Yes.
The learned CGC prays for further time to file objections to the IA. Insofar as the accompanying writ petition being WPC 3377 of 24 is concerned, pleadings are complete. Nevertheless, since the IA has been filed, seeking additional prayers, making additional prayers, let this IA be listed along with a writ petition after 3 weeks.
My lord.
It's there in the grounds also, Lordship. I'll place later on.
You please will hear list accordingly.
Lordship,
All right.
Lordship, they may not proceed with the departmental posting.
Is there an interim order?
Is there, Lordship? Interim order is there and that may.
Whatever
continue.
is there is there.
That may continue, sir.
Is there an interim order in the writ petition?
Yes,
Yes,
yes.
madam. 27
Interim order passed
2020.
earlier will continue.
Hello.
Interim order is to give you the copies.
Yes, no, that has been given to him.
Because since they have produced the letter stating that documents.
No, the interim order given like that. Yes.
All right. May I please, your lordship?
Yes.
Lordship's petition is against the recruitment process for the post of assistant librarian. Lordship, the respondent number 1 has filed its affidavit, while the other respondents are yet to file their affidavits, lordship.
You have filed a rejoinder.
That lordship won't be necessary so far as the respondent number 1 is concerned.
Heard counsel for parties. Pursuant to issuance of notice, respondent number 1.
We have filed.
Representing the General Administration Department has filed the affidavit. Other respondents are yet to file their affidavit.
My lord, I am appearing for respondent number 3, my lord, APSC, my lord. We have received the instruction, we have prepared the affidavit. It is soon for waiting, my lord. For some time we will continue.
Further 3 weeks' time is granted to the other respondents to complete their instructions and file necessary affidavit. Please accordingly.
Thank you, Abdul.
25.
Notice was issued on 19/9, my lord, that there is a disparity between the salary between the petitioner and the respondent number 12, my lord. Although my lord, petitioner is senior to the my lord.
You will have to perhaps take steps now by speed post on respondent 9.
Yes, yes.
Because registered post is become obsolete now. No longer in force. Mr. R. Borua appears for the petitioner, MSD Bora for the Health Department. MS Bora represents respondents 1 to 8, 1, 2, 3, 4, up to 8. Steps on respondent 9 be taken by speed post within 1 week from today.
Already taken, my lord.
No, you have taken by registered post, so we don't know whether it will go or not.
Order by rule, anyhow I will take.
You take fresh steps by speed post within 1 week from today. Oh, no. Sorry. 1 to 8 लिख लो अभी सर देखो that office note dated 23/10/25 reflects that notice on respondent 9 has been issued by way of speed post. Await service report on respondent 9, list after 3 weeks. You must have deposited the stamp for registered post.
Speed post already. Speed post.
Speed post.
Yes.
Then let us await service report on respondent 9. Meanwhile,
In this
the other
case,
respondents may file their affidavit.
It is taking for 4 weeks' time.
4 weeks.
Yes.
List after 4 weeks.
Date will-
Unless-
well, some date, even giving date.
4 weeks. 1st of December. 1st of December.
For admission item 26.
Yes. Reply not filed.
No, he says that no, it may necessary. It may not be
Not,
required.
not necessary.
Not.
Right.
Well, this is the challenging the 148 notice of the Income Tax Act 1961 and the assessment year is 2016-17. Lordship may kindly see page 73. A notice in the section 148 was issued to the petitioner below. Thereafter, at page 77, the regions were forwarded below. You will also make see the regions below. Also, may see para 4. Or per brief facts below details. In the above case, the information was forwarded by the DDIT investigation Dhanbad that during the course of dissemination of the information in the case of the beneficiaries in relation to the so-and-so accommodation entry amounting to 3 crore something is deemed to is detected. So-and-so is a non-flyer. Now, basis of information lot. The second finding of the investigation was the economic rationale for transferring rupees so-and-so into the bank account of the SSC from a non-filer and non-existent company would be verified. Hence, prima facie, it is apparent that the SSC has routed his unaccounted money through so-and-so to the financial year so-and-so. So allegation was that this 3 crore something was received by the petitioner from the said company.
Because it could not be verified.
So the allegation that this amount was received by me, by the petitioner. Now I will also further see, basis of forming information reason to believe in the facts and circumstances in case narrated in para 2 and 3, I have reason to believe that credit of rupees so-and-so from a non-flyer and non-existent company during the financial year has escaped assessment within the meaning of section 147 of the Income Tax Act. So the reason to believe was that, this amount of rupees 3 crores was received from the said company, which was non-existent a flyer and an accommodation entry, and thereby the income tax returns the income tax assessment was liable to be reopened. Now we'll also see page 81. This is sanctioned by the Commissioner, my lord. And the last line, only approved. Whereas the lordship will come across the Supreme Court judgment, the simply saying approved or accepted will non-application of mine. Thereafter, lordship can see page 93. It is 99, 99. Lord. The petitioner submitted reply, my lord. My lordship can see
Reasons supplied.
reasons I have given, my lord. That were the reasons.
This was the reason.
At page 77.
77, that's the reason.
That are the reasons. Subject providing of regions recorded for issuance.
Sorry. Yes.
Now, you also may see kindly, my lord, that the allegation was that 3 crore something was received by me from the said company, whereas this amount was paid by me. And you'll also see page 99. As pointed out, the transactions carried out with so-and-so limited are not accommodation entry, rather purchase were made from the said entity and the amount in respect of the said purchase was transferred
by the bank account to the entity during the year. In order to clarify the same, we are attaching herewith the purchase bills and the bank statements evidencing the transaction carried out along with the ledger account and so and so. So we submitted, my lord, that no amount was received by us. Rather, this amount was paid to the said company on account of the purchases made from the said company. And in support of that, the bank statements, all accounts were transferred to the bank account, and all invoices and bills raised by the said company were also annexed. Your lordship, can you see page 101? You see the 101 to 107 are all bank statements showing the amount to be amount transferred. And from 108 onwards are the challans and the tax invoices which were raised by the said company levying VAT. And the said company was a registered dealer during that period under the VAT Act. You'll also see page 108. All invoices and bills, tax invoices were there. Hmm? 170. Now we'll also mechanically see page 172. This so-called notice was served on Milord 29/3/2022. Now draft assessment order, you'll also see now, the SSC so-and-so files a return income assessment year so-and-so, admitting total income of rupees so-and-so. Certain information is available on record that the SSC so-and-so indulged in accommodation entry of rupees so-and-so by booking bogus purchases with so-and-so. Now the things have totally changed. When we said that no money was received by us,
Notice was identifying it as a credit.
amount received by me. Now, when I said that I have not received any amount, in fact, I paid the amount.
In the notice, it was credit.
Credit. Now it says that you purchased bogus. The purchases made by you were bogus. And this is the draft assessment order. The reasons to believe was that, my lord, 3 crore 2 lakhs.
Why is a draft assessment order?
Below under the Income Tax Act, with the sanction of the commissioner, the draft assessment order has to be passed.
Oh.
Now we also see this notice was issued on 22nd. And at page 175, we'll also see. This was uploaded, my lord. I mentioned in the petition. I was given less than 24 hours to reply to the said notice. Now, thereafter, my lord, the final order was passed, adding the amount, and the addition of the amount is 5 crores. Your lordship, can you see, my lord? To synchronize, my lord. The notice for 148 was issued on the basis of the information available that 3 crore something was received by the petitioner from some company, which was accommodation entries.
Thereafter, my lord, when petitioner pointed out that no amount was received from the said company, in fact, this amount was paid to the said company in the, against the purchases made by us, and all the bills and the tax invoices were annexed. Then the draft assessment order was my lord, passed, wherein it has been said, now reverse, that the purchases made by us were bogus, and the amount which was paid by us was accommodation entries. And thereafter, the so-called notice, I mentioned, my lord, in the petition, although it is dated you'll also may see, this is dated page 72, 29/3/2022. Lordship got it, my lord?
Page number
Page number 72,
72.
172.
Yes,
In the top, my lord, dated 29/3/2022.
yes.
Now, you'll also may see page 175. Serial number 3.
Hmm.
Kindly submit your reply response also by 23.59 hours of 33/2023.
You're reading from 172.
172, I did give the date, my lord, draft assessment order.
Then,
That was 29/3,
then which page?
page 175,
175. Serial number?
3.
Yes.
Serial number, it is mentioned, my lord.
Yes.
You are hereby so and so. 3, kindly submit a response through your registered e-filing account or so and so by 23.59 hours of 33/2023.
Yes. 1 day.
One day, my lord, you also can see.
Hmm. Yes.
So my submission before lordship is threefold, my lord. One, the reason to believe is the basic and mandatory condition for initiation of the proceedings. And if the reason to believe was formed on the basis of certain facts, and that facts comes out to be incorrect, then subsequently the same cannot be changed by the assessing officer when the reason to believe was formed on the basis that certain amount was received by the petitioner company, which was accommodation entries, and after submission of the reply to the petitioner by the petitioner that there was no amount received by the petitioner, instead amount was paid by the petitioner.
Yes.
For the purchases made, and against that the petitioner annexed the bills by which the VAT was charged as well as the challans, and the said supplier was also a registered dealer.
Yes.
The assessing officer has suddenly changed the stain and now is saying that these purchases were bogus.
Yes.
Once the reasons to believe was for the amount received and there were accommodation entries, the assessing officer cannot proceed on the basis that the amount was paid and that were purchases were bogus. In the reason to believe, nowhere it has been formed that the purchases made by the petitioner were bogus.
Hmm.
And they have not come to a finding on what basis the assessing officer is saying that the said amount is bogus.
Yes.
Now, the 3 crores amount was paid by us on the basis of which the reason to believe, although amount received, but the notice reason to believe was 3 crores something. When the submitted reply, suddenly in the order of assessment, draft assessment, it is 5 crores. Whatever amount further was paid in November, that has also been added.
Yes.
Without any basis. And as your lordship is aware, my lord, the reasons to believe, the reasons must have a live link with the formation of the belief. Here the belief which was formed that the income is kept assessment is absolutely without any basis.
Yes.
And a mechanical exercise of powers. And the commissioner has also applied his mind, not applied his mind, in granting the sanction. Because, as your lordship is aware, the judgment of the Supreme Court that mentioning of approved and accepted demonstrate that there was total non-application of mind by the sanctioning authority. And the sanctioning authority, while granting the sanction, must give reasons for granting of the sanction.
Yes.
And the last ground is that, my lord, violation of the principles of natural justice, granting of 1 day time to submit a reply cannot be said to be affording of reasonable opportunity to the SSC. And on that score itself, my lord, the draft assessment order as well as the final order assessment are liable to be set aside in cost.
Yes.
On the judgments, my lord, your lordship judgment on the income tax matter, your lordship has summarized all the judgments case laws, although your lordship has taken a different view in the matter. But that was a case where the issue was different, my lord.
We are bound by our view.
My lord.
We are bound by our view.
Your lordship is bound by your view, but that the facts were totally different in that case. These are not the facts. Your lordship has in that judgment, my lord, said that 147(1), whatever is there, if there was no disclosure or something, but your lordship has examined all the case laws. Here, the facts are altogether different. He is saying that you have received, I am saying that I paid.
What if what they are trying to show is that there was a transaction? Credit, debit, maybe.
Lord, how it can be, Lord, once I pay, I
It's a-
received, one can say that accommodation entry. I pay for purchases,
No,
how it can be?
they have come to a finding that it is an accommodation entry. Accommodation entry can be both for sale and purchases, credit or debit.
Accommodation entry can be both sale and purchase, and when I receive the bill, he has paid the VAT also.
Possible.
Anything can be without accommodation entry, anything can be said to be accommodation entry. Because they can say anything.
Where the returns filed before
Returns
the
were filed
prior to the draft order.
prior to the, originally the returns were submitted.
No. After that, after notice under 148.
No,
Not filed because of the lack of time.
my lord, because draft assessment order was there and all those things was there. So nothing was there. The only thing is that, my lord, your lordship is aware that, my lord,
the reason to believe. One cannot go against the
But-
reason to believe.
But ordinarily, they are supposed to, you are supposed to file your returns after you receive the
You know,
notice.
the draft assessment order
Uh,
is there.
yeah.
Now,
This
because
is,
the reason
this is
to,
without examining your papers.
my lord. Now, you're also kindly mentioned, the law is very settled, that the reason to believe is the basis of initiation of the proceedings. If the reason to believe, the facts on the basis of that the belief was found is incorrect, then the court cannot substitute the belief formed by the commissioner.
Yes.
Your lordship will not examine the subjective satisfaction, but your lordship will certainly examine that when the facts mentioned in the reason to believe are that amount has been received and there was a statement of income, can the assessing officer proceed now? No, like whatever amount was paid, that was a bogus purchase. Where is that bogus purchase question in the reason to believe? There is no issue of purchase in the reason to believe. Now, I receive, that is accommodation entry. I pay, then it becomes bogus purchase. So what one should do?
You are supposed to explain. this
Whereas
transaction.
I've explained in my letter, that's why after submission of my letter, they changed to now that whatever purchases you made, that were bogus. Earlier you
Why
said,
did you give 1 day's time? Is it possible that
Lordship, before
the
that,
matters
Lordship,
relating to such?
Lordship, if my land senior is completely.
No, we are.
Lordship, page 165, kindly be seen.
Let us not be so
Lordship, this
traditional or classical. We can
this
ask
is-
you a question. Even if he
This
does
is not the case, Lordship. Probably
Yes.
proper facts not been placed before your Lordship. Page 165.
Hmm.
Notice under subsection 1 of 142 was issued.
165.
Yes, Lordship. Annexure 13.
Hmm.
It was issued on 5/3/2022.
5-3.
Lordship.
Hmm.
Married, Lordship. One Lordship there, before that, Lordship, what is a 142? One is there, Lordship. This is inquiry before assessment.
So you tell us one thing.
No, Lordship, thereafter, they filed a reply. That is page 169. On 9/3/2022.
This is number 16.
169.
169.
Married, Lordship, because it is important to place before Lordship. Dear sir, we are in receipt of above mentioned notice under section 142. We have already provided documents in our earlier submission right notice dated 13/7/2021, and we have already given sufficient reason to believe that we have not done any kind of accommodation entry with Messrs. Rihanna's Re-Roller Private Limited. Rather, purchases were made from the said entity, and amount in respect of such purchases was transferred paid to the bank account of the entity during the year. However, we would like to present the additional information required by your good self along with the documents. In this regard, we would like to bring to the light of the following facts. One, Mr. Balaji Carrier India Private Limited is engaged in the business of trading and metals and ores and is earned income from sale of metals and ores during the year under consideration. 2. The copy of the computation of the SSC is enclosed for this year. 3. The copy of the all bank account for the financial year 15/16 is being attached herewith. 4. Mrs. Ryan Re-Rolling was our supplier during 15/16. 5. Although we have
done some purchase from the above mentioned entity in those years, but at present we are not in touch with the entity since last 5 years. As per our knowledge, this entity is no more in existence. Then 6, we are not aware of the details of directors right now. However, we dealt with the sales executive some Parameshwar for our business dealing during the year 50-60. They are not aware about the directors, even their name, they know about executive. Full name is not disclosed, but one short name has been disclosed. 7, all transactions were done verbally with some sales executive of Mr. So and so. At present, we are unable to remember the name of the concerned person. 8, we are attaching herewith invoice wise purchase
No, tell
details.
me one thing, what is the procedure after the notice issued? They're supposed to file their,
They file their reply. Earlier also filed subsequent to section.
then why did you give the draft notice? The
Lordship-
draft assessment order,
Lordship, may
asking
before-
them to file?
Lordship, before that, Lordship, 172 may kindly be.
No, come to the draft assessment order.
Yes, Lordship, page 172.
You have asked them to file their response. For what purpose?
Lordship,
If you don't want their response.
Lordship, before ascertaining, for passing assessment order, their response is necessary.
Correct, but you are giving them 1 day's time.
Because Lordship, 31st was the last day.
Whatever it may be, why did you wait till 29?
Lordship, before that, Lordship notice was issued to them. They have responded to
The
that.
natural
also.
justice is not an empty formality.
Because Lordship, time, Lordship in income tax, Lordship, time frame is time.
Don't issue. What if you are, see, you have issued a notice.
No, Lordship, notice was 142 was issued on 5/3/2022.
Then don't issue a reply. Why are you asking for a reply again? If you are inviting somebody to give a reply, then they'll have to give a reply. Anyway,
Lordship, page 175, paragraph 8.
all right, we will hear again on coming Tuesday.
Lordship.
Because it will require, you are relying on some judgments.
I place all the judgments, I pay the compilation,
So we'll have to,
including your lordship judgment.
can we keep it on 6th of November?
Whenever your lordship.
Lordship.
6th of November. Heard counsel for parties.
So, 6th.
This writ petition is filed by the petitioner putting a challenge to the 147 proceedings initiated. 147, section 147 proceedings under the Income Tax Act 1961 initiated against the writ petitioner. So the short case presented by before this court by the learned counsel for the petitioner is that the 147 proceedings were initiated by issuance of a notice under section 148. Sorry, 147 proceedings were initiated under issuing a notice under 148 on the formation of reasons by the Income Tax Department that the petitioner was petitioner had reasons on the formation of reasons that there was an accommodation entry amounting to rupees 3,02,75,000, which was detected in respect of a transaction between the writ petitioner and MS Rianch Re-Roller Private Limited, which is a non-filer, non-filer, FILER. Stop. According to the department, the said entity is a non-filer and a non-existent company, and it could not be verified, and therefore, on the prima facie grounds and reasons that the SSC, namely the writ petitioner, had routed its unaccounted income of rupees 3,02,75,000 for the financial year 2015-16. The proceedings under 147 has been initiated. Stop. Draft, the approval of the sanctioning authority has also been obtained without any further reasons as to why, without any further reasons in support of the sanction granted by the sanctioning authority. Stop. The further being agreed, the present proceedings, by the proceeding, the petition has been filed. Where counsel for the petitioner has urged that the initiation of proceedings is not based on reasons germane to the proceedings. There is no live link found in the reasons on the basis of which has been furnished to the writ petitioner. Stop. The approval by the sanctioning authority is also without any reasons. Stop. Further, the draft assessment order which was furnished to the petitioner was issued on 29/03/2022, inviting the petitioner to submit its response by 30/03/2022, which is just a day, and thereby the basic principles of natural justice stood violated. So the learned senior counsel submits that the notice which was issued under section 148 reflected that the amount of rupees 3 crore so and so was stated to have been received by the writ petitioner, and on basis of which the notice under 148 was issued. Stop. However, on the reply filed by the SSC that there was no income received, rather the amount stated was an amount paid by the petitioner in the course of its purchase of goods from the said entity, MS Rayans Roller so and so, the reasons, basis of the reasons which were supplied reflected that the department has formed a basis that the petitioner has purchased the purchase the goods amounting to rupees 3 crores, and thereby it was treated to be an accommodation entry, and thereby the proceedings were initiated. Learned senior counsel submits that the initial notice under 147 reflected that it was an income at the hands of the SSC, whereas the subsequent reasons supplied to the SSC reflected that it was an amount paid by the SSC. So it appears that there was a complete volte-face by the department, which reflects that there is no live link or reasons germane for reopening the assessments under 148 proceedings. Further hearing will continue on the hearing remained inconclusive as the learned senior counsel would like to support his contentions by relying on the relevant judgments. Stop. You're not filing any counter?
Not.
The respondent department also does not wish to file any counter in spite of notices being issued. In that view of the matter, let this matter be listed again for further hearing on 6th of November.
There was an item number 21 where your lordship said requisition the state council for forest department.
Yes.
We could not locate him. We tried, my lord, but nobody is responding on the phone.
We had reflected it. Forest department, you said. You
Actually,
come
the-
back at 2 p.m. You come back in the second half. We'll see.
Please, the lordship. As my senior, Mr. E.K.B. Bhuiya has recently newly appointed as standing counsel of BTC. As we don't have the relevant documents with us today, can the matter be listed after 3 weeks?
Lordship, last week and they are directed to file affidavit also.
Listed after 2 weeks.
Yeah, on date may be fixed, Lordship.
MS P. Bhattacharya appears for the writ petitioner. MS Swanzo appears on behalf of the BTC who submits that there is a change of guard so far as BTC is concerned. BTC council is concerned, council are concerned. Accordingly, the prayer of the respondent council, matter stands deferred to be listed again on
17 November?
17.
Yes, Lordship.
Right, 17 November.
Okay. What?
Referring the matter to an arbitrator under section 11. That matter was taken by my learned friend, has taken some time.
In this
Matter to file an affidavit in this case. Affidavit has not been filed.
Yes.
Lordship, we are supposed to file affidavit, Lordship. So Lordship may kindly grant us some time, Lordship.
This is my lord, apparently, yes, this is a different thing altogether. But apparently on the face of it, my lord, if there is an, your lordship, no judgment is very clear. If there is a dispute arises out of an agreement, normally it is referred. But even then, my learned friend, but only one humble request, my lord, if you can file it shortest possible time.
How much time do you want?
2 weeks time, Lordship.
2 weeks time.
Still is okay.
Mr. D. Das, Senior Counsel, assisted by Mr.
Idas.
Idas. Represents the writ petitioner, Mr. R.M. Das. The learned Standing Counsel Water Resources appears for the respondents. Mr. Das, R.M. Das, prays for further 2 weeks' time to file his affidavit, file his objections. Then
You-
it is allowed, list again after 2 weeks.
Lordship.
But 28th of November,
20, man.
28,
28.
28 or 21, whatever. 28,
21, let us.
21.
21. 21. Ah.
May it please your lordship. Lordship, before my learned senior start, my lord, I need 1 week time to file the affidavit. I prepared the affidavit and send it for vetting, my lord.
The third time.
No, last time I was not received instruction.
MS MD Bora, counsel for the
Date may kindly be fixed.
department, prays for a week's time
Lords.
to file the affidavit. Mr. B.D. Goswami, learned counsel for the petitioner, does not object to the prayer made, list again on 19th.
Lordship.
19th,
For me, it is all right, my lord.
19 November,
Lordship, obliged, my lord.
19 November.
There's some difficulty. Personal, my lord, some any other day.
You
Before
said
or-
no difficulty.
No, my lord. Before or day after, before.
Then after.
24th,
Lordship. Obliged, my lord.
24 November.
May I plead the lordship?
Yes.
The petitioner before your lordship was working as an LDA in the office of the Assistant Registrar of Cooperative Societies, Tinsukia, your lordship. He was on leave due to a minor accident for 44 days, your lordship, and by vindictive action, that leave was taken as unauthorized leave and a departmental proceeding was initiated against him. An inquiry officer was appointed and an inquiry report was submitted and the impugned order was passed penalizing him, your lordship. My lordship, the enquiry report is not given to me before the impugned order was passed, your lordship. Your lordship knows that
You filed an appeal.
lordship, it was wrongly listed in the column. Appeal, yes, your lordship.
What has happened? It is dismissed.
No, your lordship.
No.
It is kept
Appeal before
pending.
which authority?
And lordship, appeal is on
Where is your appeal?
appeal page 33, your lordship, annexure 5.
Filed before which authority? Deputy Registrar.
Lordship.
Yes. What is the status of the appeal?
My lord, that instruction I don't have. My lord, in fact, during the pendency, my lord, of the appeal, the petitioner has approached this court. Let the appeal be disposed of. My lordship may give
You
it.
get the instructions.
My lord.
This appeal was filed long back.
Lordship, this is the third occasion it has come up for instruction, your lordship.
It was filed on April 25. What is the status of the appeal? Page number 33 shows there's a receipt.
Lordship,
My lord, will take up on.
Let us wait. Let us understand what has happened in the appeal.
lordship.
You are filing an appeal. You are also coming to the High Court.
Lordship,
Programs.
that is not disposed, your lordship, then.
So is it your prayer that you are seeking a direction to dispose of the appeal?
No, your lordship. Apart from that, your lordship, my contention is that the impugned order is, I am penalized without giving me an opportunity to represent against the enquiry report, your lordship.
Have you taken these grounds in the appeal?
Lordship, lordship.
Then we will do one thing. We will close your writ petition in the present form. We will direct the authorities to look into the grounds urged in the appeal and
Lordship.
pass a speaking order.
Lordship, within a time frame.
Within
your
a time frame.
Lordship.
But Counsel for Parties, the petitioner before this court is an employee of the Department of Cooperation and was serving as what? Serving as LD assistant
The assistant, your lordship.
in the office of the Assistant Registrar Cooperative Societies till Sukia at the relevant point in time. So during his service in his last place of posting, he was placed under suspension pending departmental proceedings. Thereafter, proceedings were initiated, and on the report of the inquiry concluded, the disciplinary authority has inflicted a punishment of withholding one annual increment without cumulative effect. Stop the period of absence of the writ petitioner from 23/8/2018 to 5/10/2018 was held to be unauthorized leave. Stop. Being aggrieved, petitioner preferred an appeal before the appellate authority by filing the appeal before the appellate authority. Stop. The appeal, which is a copy of which is enclosed to the writ petitioner, reflects that the appeal was received before the appellate authority on 7/4/2025. Stop. Since no orders were passed in the appellate authority, the present writ petition has been filed, challenging the order passed by the departmental authority. Para.
Enquiry report to
Notice in the matter was issued on 6/6/2025. And thereafter, opportunity was given to the writ petitioner, to the respondent department to complete their instructions. Stop. Today also, when the matter is called up, the standing counsel for Cooperation Department, Mr. Talukdar, submits that his instructions on the status of the appeal are still awaited.
In that view of the matter, this court is of the considered opinion that since an statutory appeal has been preferred by the writ petitioner and the same is presently pending disposal before the appellate authority, at this stage, the writ petition can be closed, directing the appellate authority, namely respondent number.
My lord, in fact, the appellate authority would be the register, my lord, but as it appears, it was wrongly filed before the deputy register. So, Lord, your lordship may say that it would be the register. At page 33, the
The appellate authority, namely the registrar of cooperative societies, respondent number 3, is directed to dispose of the appeal preferred by the petitioner against the order dated so and so passed by the disciplinary authority within a period of 60 days.
60 days.
60 days from the date of receipt of a certified copy of this order. So, in the event the appeal filed by the petitioner is in the event the appeal is found to have been filed by the petitioner before any other authority, then the registrar will ensure that the said appeal filed by the petitioner is placed before the registrar, and thereafter the directions contained in the order, and thereafter the appeal shall be disposed of as per the provisions of law in terms of the directions given by the court today. Writ petition accordingly stands disposed of in terms of the above. Rest to post.
Lordship, in the appeal, there is no statement regarding that non-furnishing of the enquiry report, your lordship. I have gone, so if there is any enquiry report, it may be given for.
Petitioner will also be permitted to take additional grounds in the appeal that is already filed and pending before the appellate authority.
Yes.
Deeply obliged, your lordship.
Item 34.
In this case, I've received the parawise comments yesterday. Need a week's time, my lord, to file my reply. There is an observation, perhaps my learned friend may insist for the consideration of the interim prayer. That interim prayer is for gratuity.
Gratuity-
My lord, let my affidavit come on record. Lordship perhaps may like to hear the entire.
Lordship, there are two parts. One is gratuity, the other is group saving link insurance scheme. Group saving link insurance scheme is a small amount. Every month, petitioner deposits 90 rupees. And out of that, certain percentage is for savings and certain percentage is for insurance. And that has nothing to do with bank. And it can be released without any problem. So far as GSLI's gratuity is concerned, I would like to refer to page number 106, Lordship. This is the staff service regulation of the bank. Gratuity
What is your prayer in the petition?
Uh,
Challenging the proceedings.
challenging the impugned order of dismissal.
Have you filed any appeals?
Yes, we have filed an appeal that has not been disposed of.
Yeah.
And
That is still pending.
still pending. One letter has been issued that cannot be construed as an appeal. That too after several years.
No,
That is-
what
Yeah.
letter?
He was convicted, my lord, by concurrent judgments of two courts below. Now he has filed a revision petition challenging the concurrent convictions in this one.
We are not on this, before judicial court. We are asking you that you are challenging the order of dismissal which is passed pursuant to an inquiry. No.
No, based on the conviction.
Based on the conviction.
Third counsel for parties, Mr. A. Gagan, learned standing counsel for the bank.
Okay.
Prays for
2 weeks time.
2 weeks time to file his counter affidavit. Mr. R. K. Sharma, learned counsel for the petitioner, on the other end submits
that the gratuity and the group saving linked insurance dues payable to the petitioner have not yet been released. Stock P therefore submits that these two benefits be directed to be released to the writ petition. Well, taking into consideration the submissions made and also taking into consideration the fact that the writ petitioner has been dismissed from service pursuant to criminal proceedings initiated, pursuant to disciplinary action following criminal proceedings be initiated. We direct the respondents to examine the claim of release of gratuity and group saving linked insurance dues to the petitioner. If the same are liable to be released, then the same should be released without further delay. Meanwhile, the respondents will complete their instructions and file necessary affidavit. List accordingly.
I think. But in this case, Lordship, in the morning, Lordship, I received an affidavit filed by the respondent or whole Lordship.
Counsel for the petitioner prays for 3 weeks' time.
Lordship, actually, Lordship, no reply is required, Lordship.
No reply required.
No, Lordship. But I may be allowed to make a SG as the party respondent, Lordship.
Huh?
I'm going, Advocate General, additional account general, Lordship.
Heard counsel for parties, the respondents submit that an affidavit in opposition has been filed
Lordship, today.
today.
Today, Lordship.
The same, however, is not connected to the case record. Registry to trace out the affidavit stated to have been filed by the respondents and connected to the case record by the next date fixed. The counsel for the petitioner also craves leave of the court for implement of the accountant general as a party respondent, leave granted, appropriate steps be taken by the petitioner for implement of party list accordingly after 3 weeks.
May I please, Lordship? Kindly fix them at 2, Lordship.
Hmm?
At 2, Lordship. At 2, Lordship. And what is that they look into the matter, Lordship? He lacks in another court at 2, Lordship.
Yes. At 2.
God bless, Lordship.
Or let it come on
Next week, Lordship.
Monday.
Lordship.
Monday.
Lordship.
Item so and so. What is the item number? 36.
6, Lordship.
On the request made on behalf of the government advocate, Stan Stafford, to be listed on Monday.
God bless, Lordship. God bless.
Well, in item 37 to 41, my lord, I have received the instructions for the, I'll file the affidavit. Kindly give me 1 week time.
1 week time.
Lord.
Mr. Chaudhary,
Yes, sir. Okay.
Mr. NNB Chaudhary,
That's
the
right.
council.
38 to 41. 38 to 41.
Mr. Chaudhary.
I am appearing 37. 37 to 41, similar matter.
All right, 37,
file the
Mr.
affidavit.
NNB Chaudhary appears and 38 to 41, MSB Chaudhary appears for the petitioner. Mr. D. Nath, senior government advocate, appears for all the respondents in all the matters. Mr. Nath prays for a week's time to file the affidavit. List this matter again after 2 weeks.
So there's an increment.
Move to continue.
If they file an affidavit, you will need time to file rejoinder.
Repair.
So matter be listed after 4 weeks. Meanwhile, interim order passed earlier will continue. List this matter on 1st of December.
Lord.
Yes.
So bless.
My lord, the respondents are directed to produce the record, my lord.
Where are the respondents?
G. Burdale appears for the, they always remain absent, my lord, when the matter is called.
Border Loyalty Cooperation Department. Yes, you are there. Yes.
Lordship. I have received the records, Your Lordship.
Right.
The records, they have maintained the records in respect of attendance register has been maintained in respect of the written test, Your Lordship. The Viva, they have not maintained attendance register.
Why?
No, my lord, my petitioner specifically said he has put his signature there. 3 register were maintained, my lord.
No, but how will you know who has appeared, who has not appeared? How many candidates were there?
In respect of the
In
reserve category of the peon, there were 21.
How do you keep track? Who has turned up, who has not turned up?
Lordship, may I place it before your Lordship? They have
No,
maintained the remark.
are there no rules? Are there no rules, regulation to show how the interview is to be conducted?
Lordship, otherwise they have prepared a chart where the person who is absent, they have written it absent, and who have appeared, and who have been selected, they have been marked as selected. Lordship.
Total 21% were there, my lord. I am told, my lord, 3 register were maintained, 1 for gents, 1 for women, and combined 1 register for reserve category. Hence, petitioner has put his signature in the reserve category attendance register.
Otherwise, the signature of the petitioner and the private respondents were available in the written test. I have the attendance
Why did
register.
you maintain it for written test?
Written test, they have maintained it because there were lots of candidates who have appeared for the post.
And what basis you have maintained it? Is there a set of rules? Who is for the private respondent?
Mr. Bonik, he was there.
Where is Mr. Bonik?
On legs, Lordship, code number 6.
All right, second half we'll take up.
আমার পছন্দ কাইলে মিটার দুটার বিপরীত করে পাঠান
Wait, please, your Lordship. Lordship, matter may pass over for timing, Lordship.
Which item?
42.
42, Lordship. A private
You are for?
private respondent, Lordship.
They have already argued, my lord, only record is to be produced.
Records are to be seen. Where is Mr.
Bordolian.
Bonik?
Code number 6, same matter.
Wait for some time, let him also come.
Timing until 21. Well, here, the notices were also served through Dasti. Still, they are not appearing. An affidavit was filed on 14th of October.
Matter be placed before the Lozima Court to pass necessary orders regarding to inquire and pass necessary orders regarding service of notice.
You know, there was a Dasti service, so we have filed an affidavit.
Who is it?
Page 35, your Lordship may kindly see.
35.
And notice was sent on 4th of September. It was received in the office.
Yes.
Yes, Kamila.
Well, the process, though I am not formally, I have to file wakalatnama. I have been given instructions. The proposal has been sent to the finance matters. Everything has been finalized.
You are representing for all.
I don't have the petition also. All of them, my lords. I don't think they, my lords, Mosumi Borwes is there anymore.
Dr. Senior Counsel assisted by Ms. I. Das appears for the contempt petitioner. Mr. B. Gogoi, the counsel appears and represents all the respondents.
My lords.
Mr. Gogoi submits that you appear only for the forest.
All are
They are all
all are
from Forest Department.
Forest Department. I have a little doubt, my lord, regarding number 2. He's still there or not, I have to verify.
We are recording your name.
My lord, my lord.
It is submitted by Mr. Gogoi on instructions that the steps have been taken to comply with the direction of the court's order. He would like to apprise the court on the status of the steps taken by the department. He prays for how much time?
Next week, my lord.
After prays for a week's time, limited to be listed after 1 week. Name of Mr. D. Gogoi be reflected for the by the registry for the respondents. List. Yes.
That is 43 and 44.
The the letter of the deputy commissioner was challenged in this case, madam. So, my lord, no affidavit has filed. The affidavit is very required, madam. 2 and 3. 2 and 3 are to file.
Affidavit from whom? Which department?
Is
Deputy Commissioner.
Deputy District Commissioner, madam. Deputy Commissioner Kacha.
What is your grievance here?
Here is that a report he has prepared, madam. Additional Deputy Commissioner submitted to the Deputy Commissioner regarding misappropriation of 532 quintals of rice and embezzlement of government fund. So there is a his affidavit is required. I have challenged that letter.
Report is not here.
No, it's the last page, madam.
Report is here.
So, sir, yes, madam, report is here.
So why the affidavit is, are you pressing for an affidavit?
Till now, instructions were not received, my lord. So kindly,
I don't know, time and again, my lord, since department has filed, cooperative department has filed their affidavit. So in other cases, cooperative department has filed affidavit, but in this case, if the report goes, everything will go, my lord. So affidavit is very much important, my lord. Page 62 is the letter of additional deputy commissioner. They have to reply your document.
Lordship, kindly give some time so that we can file our affidavit.
What is the stage of the inquiry?
My lord, I do not know, my lord. There is that report they have prepared, but by this report, the department is going to take action against me. Now, all this fund, whatever it is already released by.
This is pursuant to what, a departmental inquiry?
My lord, departmental language they have initiated, but this report, I have challenged because on the basis of this report, department proceeding has been initiated, but department proceeding is stayed by this honorable court, my lord. Now, this report, my lord, whether these are correct or not, because all the funds, whatever it is, are released by the deputy commissioner itself, my lord. Subsequently, how again another new deputy commissioner comes and prepare a report on the pursuance of this register of cooperative societies. That is the page 62 is that.
By which order the proceedings are stayed?
That is in different, it's not listed today in this case, madam.
What are you challenging here?
Here I have challenged this page 15, sorry, page 62. This report prepared by additional deputy commissioner, submitted before the deputy commissioner is challenged, showing that I have misappropriated so and so rice and also fund of the society, madam, cooperative society. Now, all these fund and these are released by the finance, supply and supply department, they have released fund, not by me.
You appeared before the committee.
Yes, my lord, that everything, my lord, everything has been completed, my lord.
So
Now,
what action has been taken by the?
no, fund has been, there is the thing, the fund has been released by the deputy commissioner. And deputy commissioner himself has distributed to the agent, my lord. Subsequently, my lord, this report has been prepared by another deputy commissioner, my lord, because deputy commissioners are on changing, my lord, year after another, my lord. So subsequently, a report has been prepared by additional deputy commissioner that I have misappropriated the fund. On that basis, my lord, departmental actions are to be taken, not yet taken, but are to be taken.
Then why are you apprehending it? Let some action be taken, then only then we can find out. what
No,
is-
no, no, no.
Some-
On
They
the
may
basis
not
of-
take an action.
No, no, on the basis of this report, my lord. Whatever are there,
On
the
what-
fund are there. I have given my an annexure also.
What materials are you relying on to say that the
Yes.
findings are totally incorrect?
Yes. That is, my lord, page 43, annexure 9. And also, my lord, the page 41. That deputy commissioner has, my lord, released the fund. It starts on page 41, annexure 8. Release transportation costs and commission of NFSA rights, so and so, so and so, so and so. Then I have been asked to file a petition, my lord. There is an order dated, my lord, 2/2/19 was for the page 43. Page 43 passed by the additional deputy commissioner. Your lordship will find. Peruse the prior petition submitted by Ajoy Bosso, secretary of so and so, regarding deep freezing of society's bank account number so and so, to enable the society to disburse the transportation and so and so, so and so. Then your lordship find chairman and secretary, whereas the so and so, so and so. So these are the fund has been released. Then, my lord, I have submitted the whatever the required fund. So all this your lordship will find it was supervised the superintendent of food and civil supply. This page it starts from page 44 with my application, my lord. Your lordship will find the bottom of their signature of superintendent of food and civil supply. Now subsequently another deputy, additional deputy commissioner has come, and he says that this fund I have misappropriated. So I have challenged his report that how he can say. So now their affidavit is requirement. If that,
What is the other writ petition?
other writ petition disciplinary proceeding they have.
What is the number?
No, number I don't have now, my lord, here. One is my lord.
You have filed, you don't know.
No,
You have not stated here.
No, I have not stated here.
Why?
Because this is that has been, my lord.
How is it going to affect you?
No, because if the report goes, everything will go, my lord. On the basis of this report.
In this petition,
Yes,
you
my
have
lord.
made a submission that this report is perfunctory or
Yes, yes.
done incorrect,
Yes,
etc.
yes, my lord, yes.
Now, what action are the department going to take on the basis of the report?
No. Department there issued, my lord, initiated department proceeding by issuing show cause notice and so by the as per this report. my lord.
So
As per this report,
have you put a challenge to that proceedings?
yes, my lord, I have challenged before this honorable court.
By which-
One is
which-
one
which
petition is item 43, and another that it is not, my lord, joined with this petition. my lord.
2 writ petitions, 3 writ petitions.
No, because this is one of the writ petition, my lord, where fund has been disbursed. Whatever fund they have stated, one sum of amount has been disbursed. In favor of this writ petition, item number 43. CS also, my lord, I have to state everything, my lord, until and unless let them file an affidavit, my lord.
No, they will file. We
Yes,
want
my
to
lord.
know how many writ
No,
petitions.
then, my lord, that writ petition, my lord, I have to, my lord, that
What
need
purpose
to
have you
record.
filed a writ petition?
That today I don't have this
You don't
number,
even
my lord,
remember-
along with me.
you don't even remember why you filed.
Oh, sorry, my lord. So I have with it there. WBC number 254 of the 24.
254.
Yes, my lord.
All right. Let this writ petition be listed along with WPC number 254
2024.
of 2024. After 2 weeks, by which time the respondent will apprise the court the steps initiated. By which time the respondents will complete their instructions, if any, and endeavor to file their affidavit, if so advised. So these are how many matters? 2 matters.
3 matters.
Here 2 matters, now set.
43, 44.
Yeah, 43, it had only two meters.
WPC number is so, what is the number?
254 of 24.
254 or 24? List accordingly.
Of that.
45.
This matter lordship, day before yesterday lordship, we have filed our rejoinder lordship, which is not on record lordship. Lordship, matter may come up after.
Counsel for the petitioner submits the rejoinder affidavit has been filed. Stock the same, however, is not connected to the case record.
After a-
Registry to verify and connect the same to the case record and list the matter after 1 week.
So,
Mr. T.C. Sutia appears for the respondents.
Development.
47.
Right, this is Lordship. Lordship, in this matter, the impugned transfer order was put under challenge. Lordship, I
Some
was,
rejoinder you have filed.
yes, Your Lordship. In my rejoinder, I have stated, Your Lordship, that they have given some show cause notices that were issued in the year 2020. And now punishment is given in 2024. And they're talking about the performance appraisal. That has nothing to do with the transfer or termination. It is only for the hike in the increment in the salary. There has nothing to do with the transfer or anything. And they have admitted the fact that it is a punitive transfer, Your Lordship. Yes.
Where is the order of transfer?
Order of transfer is at page 19, Your Lordship.
What is the ground that they have stated in the affidavit? Affidavits filed, no?
Affidavit filed, Your Lordship. They are saying that there is a complaint from the Deputy Commissioner that my
What is the affidavit?
Page 36, my lord.
36.
36. Para 5, my lord.
Yes.
But Your Lordship, regarding this letter of the Deputy Commissioner, no intimation was made to me, Your Lordship. Neither was given a chance to defend myself. Whereas I have done all the required jobs on time itself, which I have stated in my affidavit.
My additional affidavit, my lord, filed on 19/9/2025, my lord. In my additional affidavit, she was served several focus notices, my lord, since 2019, my lord. We have annexed more of them. In 2019 to in 2022, her performance was very poor, my lord. Focus notices was issued several times, my lord.
Hmm?
Focus notice was issued
Hmm.
to her, my lord.
Where is that?
In my additional affidavit, my lord.
Hmm.
Page 65. '67, my lord. Several focus notices are issued to her.
But there are not related to me, Your Lordship. If you refer to the block program manager, Your Lordship.
She's
And I
a
have filed
block data manager. She is working at, was working as block data manager.
And it is to the block program manager.
In her name, my lord, it is 2020 69, page number 69, my lord.
Then in 2020,
Even,
they have issued the
70
course.
70 and 71, that is on 2022, my lord. Series of so-called notices.
When did
were-
you reply?
I replied it at that time itself, but it didn't keep the copies, Your Lordship.
Huh?
As per the
No
inspector,
copies.
No.
There is no reply.
It is not
Sorry,
my-
Lordship, may
You
kindly
have issued
appreciate-
show cause. Was there any reply to the
No,
show
no.
cause? No.
No, they didn't take any action at that time, Your Lordship. This is 2020.
But you did not reply.
I had replied, but I didn't keep I had mailed them everything.
You have mailed them, you recover it from your mail.
This time, I don't think it will be possible for me to recover.
Why?
If, well, Lordship, kindly appreciate the matter. In 2020, they have given me show cause. Okay, I admit. But now in 2024, you have given me a punitive transfer.
Their case is that you did not respond to the show cause. In spite of repeated warnings, you have refused to.
Lordship, may kindly come to my reply, Your Lordship. Kindly.
Yeah. Page
Page
number?
76, Your Lordship. It starts from page 76, paragraph number 5. If I have stated. Paragraph 5, that with regard to statement made in para 3 of the affidavit filed by respondent 2 and 3, respondent begs to state that in para 3 of the affidavit, it has been stated that the deponent was found irregular on duties, which is totally false statement. As the deponent did her duties sincerely and submitted. Moreover, in regard to communication that have been annexed, here I have specifically stated, Your Lordship, regarding all this in letter dated 29/3/2019. The role here is to be played by the block program manager and block community mobilizer, not by me. And then in the second paragraph, Your Lordship, in regard to letter number 30.
How are we to decide on this issue whether you are supposed to send or somebody else is supposed to send?
Lordship?
You are challenging this transfer
order, Your Lordship.
It's a transfer order.
Lordship.
On the ground that there is no basis. And show cause notice was issued 2 years earlier and thereafter the transfer order has been passed.
Lordship.
But their case before the court is that in spite of repeated warnings, caution, you have not improved yourself. You did not reply to the show cause notice.
I have replied, Your Lordship. I have given my replies in all this. And moreover, Your Lordship, you can kindly see.
Give us some indications from somewhere that you have given a reply. What have you, all these things that you have stated in the affidavit? On which reply, which date you have sent it, how you have sent it? If you have sent it by email, then you can recover it from the email.
I have to seek instruction on the.
Yes, please do. Counsel for the petitioner
submits that the replies which he had submitted in response to the order passed by, in response to the notice issued by the respondent authorities are not available with him. He craves leave of the court to complete his instructions in this regard from the writ petition. Prayer made is allowed, list again after
1 week,
how much time? 3 weeks?
2 weeks ago.
2 weeks, yes.
Obligation.
Ms. Ebora for the respondent.
48.
But the issue involved in the expedition is very short. Whether, there was a suppression in or suppression of fraud with the intent to evade the payment of tax to enable the department to proceed with section 74 of the act. You'll also kindly see, page 67.
Yes.
The work order was issued on 8th of December 2010 to me, and thereafter you'll also find at page 68 the completion certificate. The work was completed on 31/10/2020 at the last line. The work was completed on 31/10/2020, the last line at page 68. Page 69, you'll also see. An escalation bill was prepared and you'll also see the bill was prepared and you'll also say the bottom, the GST and CGST were deducted in the last portion below. Have you also got it?
Yes, 1%.
The CGST 1% and 1% SGST was deducted. And the payment was made in the last handwritten, you'll see 2010-2022. The signature below. Now, in the IT return, this was on 22. So it will fall in the assessment at 23-24. In the IT return and audit report, page 83. My lord, and the relevant part at page 85. You also find the schedule of the current liabilities. And you also got it, my lord. The GST payable 4.28 crore something.
Yes.
Now, the TDS was received by the petitioner is page 99, you'll see page 90 and 99. You could say Carlos. No?
99.
96 million.
96.
Upload position. 96 and you'll also see the right hand side, the 27 crores. Page 96 million. We took the upload code to this return. 27 crores. This is after deduction of the GST liability. So the GST I've shown 4 crores something. And this was the net after deduction of the GST liability that was disclosed in the income tax return. Thereafter, page 99.
Yes.
About this, as per the provisions of the Act and the rules, my lord, whatever TDS is deducted, that department uploads it in the website. You will also kindly see Rule 66. Copy the. Form and manner of submission of the return by the person required to deduct a tax at source. Every registered person required to deduct tax at source under section 51 hereinafter in this rule referred to as the deductor shall furnish a return in GSTR 7 on or before the 10th day of the month succeeding the calendar year electronically through the common portal, either directly or in the form of facilitation center notified by the commissioner. The detail furnished by the deductor under sub-rule 3.1 shall be made available electronically to each of the deductees to the common portal after filing of the Form 7 for claiming the amount of tax deducted in his electronic cash ledger after validation. So, my lord, the person who deducts the tax, he has to give the details in GSTR Form 7 and also you can see. And that has to be verified and accepted. Now, you'll also see this was uploaded on 12/12/2022. At page 99, you'll also see. And it was accepted, you'll also see at the TDS credit received. Central and CGST accepted. You also got it, no?
Yes.
So whatever TDS was deducted by the department who made the payment, that was uploaded by the said department, and accordingly the same was accepted by the SSC and posted on the portal.
Yes.
Now, a search and seizure was conducted by the department in my premises, and after conducting the search and seizure, my lord, the allegation is that I have not disclosed this 36 crores which I received to the department, and the department were not aware of it. And thereby, my lord, they invoke the power under section 74 of the Act, which I will place before Lordship, my lord. And my submission before Lordship is that, my lord, that this information was very much available with the department, which is available in the GST portal itself. Now, the last date of the submission of the return, annual return, was 31/12/2023. And I submitted the annual return.
28/12.
You want it? 28/12/2023. Now, their contention is that, my lord, that the search was conducted earlier. And if the search would not have been conducted, then in the annual return, I would not have disclosed it. My annual return last date is 31/12/2023. Prior to that, 28, I had submitted my annual return. Although in the annual return, I claimed it to be exempted. But the question which falls for consideration is that whether it will fall under section 74 of the Act or not. You'll also kindly see section 74 of the Act for the time being.
Yes, speak.
Up there. You'll also take this book, Mullah.
Uh, 74.
74.
Yes.
I will read only subsection 1 below.
Mm.
Where it appears to the proper officer that any tax had not been paid or sought paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized by reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall sub so and so, so and so. So the condition which are required to be fulfilled is that there must be fraud or willful misstatement or suppression of facts to evade tax. Now, in the present case, you'll also find there is no question of any fraud. They are also not saying fraud. There is no misstatement of facts. Only they are relying on the suppression of facts to evade tax.
Yes.
Now, this three terminology, my lord, have come up for consideration before Apex Court as well as before Lordship also. Lordship has also considered the section 74 of the Act and has examined as to when it can be said to be fraud, suppression of facts, and misstatement of facts to evade tax. Now, when the information was available in the portal of the tax deducted on a particular turnover, in the income tax audit report, it is available. I have filed my return before the last date of the submission of the return. Can it be said that there was any suppression of facts? I am posing a question to myself. The 31st December is the last date for filing the return. They come up and make a search in my premises in April and say that no, your return may be 31st because we made a search. Then only we came to know you would not have submitted the same figures in the annual return. If somebody is not submitting the return or is not disclosing the figures in the return before the last date of the submission of the return, one can say, although that will also disputed, because the Supreme Court has also said that only not providing certain information will not amount to suppression of facts unless they prove that there was an intention to evade the payment of tax.
Yes.
Now, my submission before the Lordship in this case is that there was no suppression of facts in as much as all the facts were available with the department, and the petitioner has also submitted its return, annual return, before the last date of submission of return, and has also disclosed this figure. And thereby only because the search and seizure was conducted prior to the last date of the submission of the return, it cannot be presumed that the petitioner would not have submitted the return and would not have disclosed the figures in the annual return, and thereby the same will amount to the suppression of the facts. If your Lordship permit me, I may place before Lordship a few judgments. Lordship, see para 12.
What was the return file? Was it a nil return?
It was, amount was mentioned, it was mentioned exempted. Now that has also been laid down by the Apex Court, that claiming something exempted, and the reason for claiming the exempted, I will place before Lordship, reason was that, the reason was that the work order was 2010, where the GST was not there. And there was a dispute, divergent opinion whether this will be taxable or not. But the question is about separation, Lordship, can you see para 12? In respect of the Central Excise Act, section 11A, the same phraseology is there. The expression separation has been used in the proviso of section 11A of the Act, accompanied by very strong words, fraud, collusion, and therefore has to be construed strictly. Mere omission to give correct information is not separation of facts unless it is deliberate to stop, evade the payment of the duty. Suppression means failure to disclose full information with the intent to evade payment of duty. When the facts are known to both the parties, omission to one party to do what he might have done would not render it to separation. When the revenue invokes the extended period of limitation in section 11A, the burden is cast upon it to prove separation of facts. An incorrect statement cannot be equated with a willful misstatement. The latter implies making an incorrect statement with the knowledge that the statement was not correct. So, my lord, with this observation,
Where are the returns here? Is it?
I have next copy, return copy. Annual return. Page 100, my lord.
100.
And also find at page 100A, E, my lord.
Nil rated.
My lord. D, my lord. D.
Exempted.
Exempted, the amount is there. The issue is about suppression of fact. The question is not whether taxability or non-taxability.
So what is where is the show cause again?
Well, so called you'll also find page 132. part kotha hai? You'll also find relevant part at page 145. At the bottom below. Where is it?
Yes.
Suppression of fact by the noticee. Section 74 of the Act, so and so, Assam, so and so, is there, my lord. You'll also skip over. Then section 74 has been quoted. In para 2.2. In this context, it is submitted that the noticee is government contractor and, my lord, maintenance of the so and so, the what was it, 11 part 2? 7.3, my lord, the finding is there, my lord. it has also been noticed during the scrutiny of the record submitted by the noticee in course of the investigation that the noticee has failed to self-assess and pay their GST payable correctly for the period from so-and-so, GST period for the period so-and-so, amounting to rupees so-and-so, which in the opinion of the GST, which in the is a evasion of GST in contravention of the provisions of the section so-and-so of the act. Well, what correctly, my lord, the department want to say, my lord? That there is a provision of self-assessment paid the taxes. And since it was not self-assessed and tax was not paid, there was a evasion of tax. Now, evasion of tax and evasion of tax by virtue of suppression of facts are altogether different. I may claim, my lord, an item to be taxable at the rate of 3%. The department may come to conclusion that it is taxable at the rate of 18%.
You mean to say short paid and evasion are two different?
The two different things. You also consider, my lord, the issue in the case of the juice, lemon juice, and all those issues, where the petitioner was claiming it to be 8%, and the department said that it is 18% plus the cess. Wrong classification of an item and payment of tax at a lower rate cannot be said to be a suppression of facts for the evasion of tax. Now here they say that it was obligatory on the part of the SSC to self-assess and pay the tax. And since it was not paid, and thereby there was an evasion of tax. Well, for that, Section 73 is there. Section 73 is a cases other than fraud, other than the misstatement, and other than the suppression of facts. They can assess, but one cannot invoke the powers of Section 74 of the Act with the extended period of limitation on the ground that there was suppression of facts and evasion of tax, which led to the evasion of tax. And there are so many Supreme Court decisions, including the decision by your lordship, where all the decisions of the apex court have been considered. And your lordship has held that the invocation of the power under Section 74 was illegal. I will place that judgment of your lordship also. It is a voluminous judgment about more than 140 pages. Recently, it has been reported in the All India Journal also.
Fruit juice.
Fruit juice. No. So, your lordship, on the basis of those facts, every fact laid down the law, that in which case it can be said to be a suppression of facts leading to evasion of tax. Now, the petitioner having disclosed every details, and if there was an intention to evade tax, my lord, then in the income tax return audit report, the petitioner will never disclose the turnover and as well as the tax payable. The petitioner will never accept the TDS details which are furnished in Form 7 and accept that, yes, this is the TDS deducted source. Now, once the TDS deducted source in the GST is available with the department and they know it is to be 1%, can it be said, below, that the information was not available with the department? And can it be said, my lord, that only because the search was conducted, this came to a notice of the department, and had the search would not have been conducted, then the petitioner would not have disclosed the same in the annual return when the last date of the annual return has not expired. Well, I will made a compilation of all the judgments, including the judgment of your lordship, on the same issue, that when it can be said to be suppression of facts, and the apex court had made it absolutely clear that non-disclosure of facts also itself will not amount to will not give power to the department to invoke the extended period limitation unless it is with the intention to evade the payment of tax, and which must be proved that the intention was to evade payment of tax.
Where is the show cause again?
Well, the so-called I placed before Lordship, my lord. Page one, it starts with page 132. And the relevant part they have discussed is in 146. I will also kindly note it, my lord. 7.3 at page 146. It says, my lord, that since the amount related to 17, 18, 18, 19, 19, 20, the petitioner failed to disclose the same in the annual return and had paid the taxes. My lord, the escalation bill was prepared in 2020 and the payment was received in 2022. How I will come to know in 2017, 18, 18, 19 that any amount will be received by me?
Which paragraph?
Paragraph 7.3 at page 146. At the bottom below.
Yes.
What they are saying, my lord?
No, you said that TDS was already reflected.
TDS was reflected.
Portal.
Portal, I accepted it, and that is as per the rules.
But TDS amount is less than this amount which is demanded, or is it inclusive of interest and penalty?
My lord, this amount interest has not been calculated as yet. Penalty will be 100%. Let's see if we find the directions. At page 148.
No, what we're saying is this, what I want to understand is this amount, GST amounting to the figure which is reflected para 8.1. Is it inclusive of the TDS?
Well, TDS, it appears that TDS has not been taken into consideration.
But even assuming the TDS is taken into consideration, there will be some amount according to the department payable.
Yes, yes. Well, I have no objection so far as the determination of the tax is concerned by the department. The issue is whether invocation of power under section 74 or 73 of the Act.
73, the limitation must have crossed.
Yes, whatever may be, but otherwise I would
That
not
is
have.
the reason to invoke 74.
Otherwise, I would not have come before Lordship. But the question is that, in taxing matters, as your Lordship is aware,
by the book,
there is no equity from both sides. The department has failed to perform their duty in time. Then, my lord, the similar is with the SSC. If the SSC, my lord, fails to perform the duty, there is no equity. So it must come within the purview of the preconditions of section 74 of the Act. And it's not so that the 73 notices though issue, all the assessment years will go. The notice was issued in 3 years, within 2023. So 2023, may not at least for 2 years, they will have the chance. But if we delay the matter for further, 1 more year may go. So the department, in the anxiety of, my lord, saving 1 year, may have to lead to the losing of 2 years. So, my lord, if your lordship, after hearing the other side, they file an affidavit also. And your lordship may fix after 3 days, 4 days, whatever the lordship fix. Then I may, my lord, make a compilation of all the judgments of the apex court on the only this issue, when the extended period of limitation can be invoked. And in
Yes.
fact, my case squarely falls in the cases where the Supreme Court has said that extended period of limitation cannot be invoked. All right.
In this case, we have filed a affidavit. In paragraph 6, we have narrated, let's say, why, what, under the what circumstances we should notice under section 74. And there is a clear case of suppression of fact. But if they have not, they filed the return with nil. So this is if it is not a suppression of fact, then let's say in what case?
Return does not reflect it is nil. It's
Yes,
just
Lordship.
exempted.
Yes, Lord, it is, they said it is exempted. We have explained in our affidavit. Lord, we come to paragraph 6.
In one case, we will rely on, what is that? 26 AS form.
No, that is Lordship in service tax, Lordship.
No, no, what we are
GST
saying,
also?
this is by another government organization where whatever taxes are paid are reflected in the portal.
Lordship, that is also be pending before consideration whether data is available under section 26 H can be relied on imposing tax, service tax.
All right. Okay, we'll continue. Right, counsel for the parties. This matter will require further hearing. The question of whether the show cause notice issued by the department under section 74 of the CGST Act satisfies the preconditions necessary for issuance of such a show cause notice. Matter has been heard at some length. For further hearing, we stay again on
Maybe 6th minute.
20.
6th minute, one matter you already fixed it.
26th.
Lordship it may count 7th, Lordship, because 6th.
I'm not there, but 6th is, your is fixed up and Mr. Kyal is there.
Yes,
It
Lordship.
6th.
is very difficult to catch him.
Court number 1, Lordship, many matters have been fixed on 6th.
Eleventh.
Lordship.
11%.
11th.
Much.
11. Mr. Dhor, you're appearing?
Speed of duty, man.
Oh, okay. Mr. Raj Dhor, if you.
Get through, madam.
Please, Your Lordship. Lordship, with regard to this application, the issue involved is with regard to that their main stand is that the section 21 applications, the notice which we had issued was not in conformity with the arbitration clause, and hence they have refused to appoint the arbitrator. Now, the arbitration clause, your lordship will find at page 75, your lordship. '74, '75. Clause 45 is there, and actual, as per the GCC, it is 64, which your lordship will find at page 75. If your lordship has got it. 64(1)(1). In the event of any dispute or difference between the parties hereto as to the construction or operation of this contract, the respective rights and liabilities of the parties on any matter in question, dispute or difference on any account, or as to the withholding of such and such of any certificate, except for the accepted matter referred to in this, after 120 days, but within 180 days of his presenting his first claim on the disputed matter, shall demand in writing that the dispute or difference be referred to arbitration. Now, this is the main clause, your lordship, and thereafter it is required as that they should make the appointment.
Where is your reference to for
Yes, first of all, the final claim which I had raised, your lordship will come, may kindly come to page 159 of my application, annexure L. So as per this act, the clause, I have to invoke the arbitration clause after 120 days, but within 180 days from the date I present my final claim. So this was the letter on May 3rd, 2024, by which the final claim I had raised here. Now, subsequent thereto, they had asked us to make some adjustments with regard to, on receipt of this letter, in page 161, annexure M1, the respondents had referred to my final claim and said that I make some adjustments with this. Then again, on the basis of this correspondence from the respondents, in page 162 M2 is my rectified thing, whereby a portion of that claim was modified. Now, within 180 days, section 11 notice as per annexure N1 at page 164 was issued by us. This is the application.
no, after 161? You filed
I filed a response.
162.
162, which regard to not changing entire thing, but only the part they wanted the corrections. Thereafter, as they did not respond to that, as per the clause, I raised my section 21, as per that, the final thing,
164.
164. Here, notice under, that is the only issue here. I had referred in the notice, section 11 of the Arbitration and Conciliation Act, not the arbitration clause 64(1)(1), which is there. And because of which they have refused it. Your lordship will find at page 168 at annexure O, they say, if your lordship comes to page 168, they refer to my letter, which is at annexure N1 at 164, and they say, in reference to above, the subject is regarding appointment of arbitrator. Then they say, in reference to above, it is to mention that you have submitted one notice under section 11 for the appointment. As per contract agreement, there are clauses for appointment, but in the instant case, you have submitted notice under section 11 instead of notice under such and such. Hence, there cannot be entertained. So their concern is I have to make a specific reference to the clause in question. And because I have failed to make a reference to that, the arbitration clause cannot be entertained. The request cannot be entertained. Now, for that purpose, I'll take your lordship back to the arbitration clause at page 65. 75, and take your lordship to page 77, which is clause 64.7. Here your lordship will find
Page number?
page number 77, which is a continuation of the arbitration clause. Because arbitration clause is 64.1.1, and thereafter it is broken up. Then 64.7, subject to the provisions of the arbitration and conciliation and the rules, because it states that the Arbitration and Conciliation Act and its rules will govern the arbitration proceeding. So my
Less-
submission before your
Then
lordship,
20%.
yes. So my submission would be, your lordship, that they have not stated that they have, the intention is there. They have understood the intention that I have invoked the arbitration. But they have taken a technical plea that because I have not made a specific reference to clause 63 or 64, they are not entertaining my application.
What is the effect of 64.7?
64, what I'm trying to say, that the arbitration, because I have referred to section 11 of the Arbitration and Conciliation Act, it has to be read, the whole arbitration clause merely on section 11, because they understood that it is a request for appointment of an arbitrator. Section 21 of the Act says that my intention, a party invoking the wish to go for arbitration has
No,
to.
is it their case that 64, notwithstanding whatever section you apply under,
Yes.
it is only in the event of satisfaction of 64.7, that is, it must be less than or equal to 20% of the value.
That is,
Arbitration.
that is there. And secondly is that within 120 days, within 180 days, but after 120 days, my request has to go. There is no specific per se requirement for this. And even assuming this, the very reference in the letter that your request for arbitration is being refused.
It is clear that after 120 days, but within 180 days.
Yes, sir. That is also not the issue by them. They have not raised that you have not come within that specified period. It is also not a case that the claims go beyond the cutoff embedded in the clause, that you go for civil. If it is exceeding that, you have to go for civil. The only issue before them was, and the ground they have taken is that I had not specifically quoted the arbitration clause. But my humble submission is the intention of the party.
Where is the notice again, reply again?
The reply, your lordship will find at page 168, your lordship, annexure O, your lordship. The subject clearly states regarding appointment of arbitrator. Then they say, with reference to above, it is to mention that you have submitted one notice.
Mean to say?
My lord,
That notice not issued under 63, 64, therefore not acceptable.
No, my lord, continuing from what my learned senior has submitted so far, my lord, the pre-arbitral process under 63, my lord, there are two clauses. If I may take, my lord, to page 74.
Yes.
My lord, page 74, clause 45, where the arbitration provision starts, my lord, if I may take, my lord, to page 74. Page 74, clause 45, 45.1 says, my lord, arbitration of and settlement of dispute shall be governed by clause 63, 64 of the GCC and railway edition, which are reproduced below. Now, my lord, 63 at page 75 is a pre-arbitral step before coming to 64, which has not been done, and which our contention is, it is mandatory.
No, what is to be done? That is what we are trying to understand. 63, 64, what is
In 63, my lord, 63 is a pre-arbitral process where a representation has to be given to the general manager railway. If I may read, my lord,
And this representation is given to whom?
the general manager, and this representation was given to, my lord, the authority below the general manager, not below, my lord, to a different authority rather, the chief engineer construction. But the representation first has to go to the general manager, and if he fails to decide within 120 days, then, my lord, comes 64. That is the stage of demand for arbitration.
Now, what is your objection here?
Our objection is, my lord, that the pre-arbitral process as provided under the contract agreement as agreed to by the parties before approaching for arbitration, that has not been followed, and it is.
To what effect? To what effect?
No, they have made no representation before the GM.
GM. And what reply was given by the chief engineer?
Nothing.
Nothing. It is not the case of.
Because he was not the
May not be,
authority.
but was there any reply saying that I am not the authority? You follow the procedure under.
The final reply at page 168, my lord.
That
says.
That is after the period of 180 days.
Yes.
And
so once this process, the general manager who has executed the contract?
the chief engineer,
Chief engineer.
deputy chief engineer, if your lordship sees at the bottom of the contract agreement, at the bottom, the signature is there.
So he is the employer.
And my
Yes.
learned colleague has
First party.
stated. But he had responded to it, he has not denied that. He merely asked us to make some modifications. Because it was replied to, they did not say that I'm not the authority concerned to send the final claim. In fact, they responded to it, asked us to make some modifications, which we did, your lord.
And, my lord, the communications which have been referred, my lord, two communications, that is annexure L and M. My lord, those annexures nowhere says that, my lord, they are going to seek for an arbitration.
No, because as per 64, you are to raise your final demand, final claim.
Yes, my lord.
And within 120 days.
No, before 64, my lord, 63 has to be complied, my lord. A representation has to be there to
No,
be.
no, representation was issued to the first party of the contract.
No.
If the first party, which is an officer subordinate under the officer mentioned in 63,
No.
there could have well been a reply saying that I am not the authority, please redirect it to so and so. Or he could have merely forwarded it.
No.
But instead, there is a reply given to say that there are some modifications required to be done.
Yes.
Why? If it is not authorized,
No.
why did he give this reply? Where is that modification?
The letter which they responded to with regard to the final claim.
161.
Yes, your lordship. And we have referred to the letter of the final claim in the reference. They have asked us to make some adjustments and recalculation of the PVC bill, which we did and submitted back to him. But there was no response. And in their refusal, they have not taken the plea of drawn submission before the inappropriate authority. Their main contention is clause 64 or 63 has not been specifically referred to. And they understand that the content of the letter clearly says that they understood my intention of seeking for an arbitration.
There are judgments on this.
Yes, there are judgments. Now, and your lordship, as per this, the new inserted clause 6A of 11 has clearly
Arbitration, like, okay.
clearly confined the adjudication, Your Lordship. If I take Your Lordship to the judgments, if Your Lordship sees, because after 2015 amendment,
Have you supplied a list of books?
yes, I have the copies. My,
Why don't you supply a list of books so that we also get an opportunity to refresh our memory so far as the judgments are concerned, because
yes, Your
there are
Lordship.
judgments of this court, perhaps on 63 and 64 also.
Okay. Yes. Then,
Perhaps on 63, interpretation of 63, 64
there is a judgment.
would be there.
Yes.
I think Mr. Gogoi was there, your colleague.
Yes, ma'am.
You may inquire from him if he is there.
Okay, then, Your Lordship, we can place it before Your Lordship with regard to that particular.
What are you saying regarding 6A?
6A, after the 2015 amendment, the thing has been, there is some latest has also come, that only now, before we used to say with regard to limitation, etc., also was within the ambit of the court while exercising power under 11(6). Now, this particular section has been inserted whereby only the existing of a valid arbitration clause is to be looked at. And there has been a recent 2 or 3 judgments.
Valid existence of a valid arbitration clause will also mean whether the requirements in the arbitration clause
No,
are
that
fulfilled.
that would be there, but with regard to, there was another point with him which it was there with regard to limitation, etc., was there. So
No,
those facts,
I think this is within limitation, 180 days.
180 days, those factors are to be decided by the arbitrator.
That is,
Because that comes into that is the interpretation that
Competence.
which comes within the ambit of the
Yeah.
jurisdiction of the
Tribunal.
tribunal under 16. So this aspect, as per 6A, as per the judgments which has come, says that those has to be left to the tribunal. I'll leave your lordship for
One view. The other view is that what is the point in referring to it if the price
Understand.
policy doesn't appear to be arbitrable?
if the dispute is not arbitrable also, that is to be before the,
No.
yes,
There could be a view that arbitration is a matter of agreement.
yes.
Referral court is to see the existence of the agreement. Now, this agreement may not be plain and simple agreement.
Yes, there may be
Agreement
interpretation.
conditional, as in this. So therefore, while examining the existence of an arbitration agreement, should the, can the referral court not look into this aspect that whether the conditions necessary to be fulfilled, have been fulfilled or not? In order to really
To exercise the power to appoint an.
because the 11(6) will start from the day
Section 21 notice is
21 notice is issued, with the 2 months after that, if they don't reply.
then the right starts flowing.
So if prior to section 21 notice, is there any specific bar that notwithstanding any conditions, if 21 notice is issued, the process will start on? I don't think there is any
No,
restriction.
there is
that
no such thing, but
Section 21 is not,
no, section 21 does not prescribe any such
it says unless otherwise agreed.
unless otherwise agreed.
It's not a non-obstantive clause.
The non-obstanting clause, there is a judgment of this Cox and King's judgment latest. I'll place it later on your lordship. On the thing I will try to satisfy, and he will bring on the 63 interpretation.
So the only question is whether non-service of notice to the designated authority has rendered the very initiation of process of arbitration
Bad.
bad, or
bad.
is it premature?
And another aspect, your lordship, once they have exercised their right in refusing my appointment without raising this plea, whether this can be taken as of now? Because
63, 64, we have stated. that it's not
64,
followed.
63, they say that I have not quoted the section. But they have not stated the request has been made without complying with the provisions of 63. Two different things. Though they have mentioned 63 and 64, they merely say that you have only mentioned section 11 of the Arbitration and Conciliation Act without referring to clause 63 and 64 of the GCC of 1998. Now, the additional issue which they have brought on record, whether that can be,
If you had given a list of books, we could have closed it today itself.
okay, any. Can it be on Monday next year?
It has to be thereafter. Can be on 12th.
Yes, Your Lordship.
12th or 14th. 14th. 14th.
13th.
14th. If 14 is all right with you.
Yes. Yes. I'll furnish it before that, Your Lordship.
List this matter again on 14th of November. The council for the parties are permitted to supply the list of books, list of judgment they will like in support of their contention prior to the next state of listing. Mr. will discuss for the petitioner, petitioner and Mr. H. Gupta for the respondent. Yes.
Item 52 and 53.
This is with regard to transfer of the petitioner on the basis of a notification which is already impugning this declaration. But by last order, Lordship wanted to peruse the records if it was an extraordinary transfer or the ordinary transfer. So they will be facing.
Where?
Yes, Your Lordship, that first I have given the list. That is, that starts from 32 to 40. So on the day when the order of the writ petitioner has been passed, it is not a singularly striked out from the chain of the transfer. And besides that, this is a regular exercise after March, Your Lordship. And
No,
thereafter,
the question is that whether you can go for transfer a person who is an office bearer.
yes, Your Lordship. Now, Your Lordship, the writ petitioner is claiming the benefit of the transfer policy clause number 20.9. So, Your Lordship, before going into that transfer, he has to be transferred within the meaning of the transfer policy. So, for that, we have placed in clarification.
No, records were called for what purpose?
Your Lordship would like to check that whether it has been by way of this advisory or not. And our saying is that it is in regular exercise. And it has been transferred within the same center under clause 2 of the transfer policy. It is just in placement, Your Lordship.
No, the office records will indicate what internal or what authorities have taken. You have given the records of the person concerned.
Yes, Your Lordship.
We don't want that.
Okay.
We want how do you take decisions? How do you decide that a transfer order or transfer orders are to be effected? There must be some notings in some files to show that yes, this is a process which has been initiated at such and such level on such and such day. You have given the personal file.
Yes, Your Lordship.
That we don't require. What will you do
I'm
with the
sorry, Your
personal file?
I'm sorry, Your Lordship.
It is clear in the order that there was a movement shall be transferred and has been given movement orders.
Yes, sir.
So we wanted to see the records. Personal records, what would you do?
No, Your Lordship, I just misunderstood that, Your Lordship.
The bank may not function like a government office, but there must be something to indicate.
Yes, Your Lordship.
You suddenly don't issue a transfer order. It has to be routed through.
That
the
how it
process.
has been routed through, Your Lordship.
How it was initiated, what was there, whether any objections raised. We just wanted to see that.
Yes, sir. I'm very sorry, Your Lordship. I misunderstood the. But Your Lordship,
When can you get it again?
Your Lordship, day after tomorrow, maybe given or.
Not on Friday.
Kindly consider on second week then of November.
You are enjoying an interim order.
Yes, Your Lordship.
Then 7th?
Yes, sir.
7th.
Maybe.
List this matters again on.
Very
7th.
sorry, Your Lordship. Very sorry.
No, it's okay. Maybe order, we thought it was clear enough.
Yes, Your Lordship. Now it is
The-
clear to me.
By earlier order dated 17/10/2025, the respondents were directed to place the records. Stop the court was of the view that that the court place the records relating to the transfer of the writ petitioner and other similarly situated persons. Stop. However, today the Learned Standing Council has placed some other record which does not contain which does not reflect the process of the steps for the initiation and issuance of orders of transfer. Mr. M. Sharma, Standing Council, submits that the appropriate records will be placed on the next day, as agreed to by both parties, list again on 7 November.
Like not.
The records which were placed before the court are returned back to Mr. Sharma.
Like.
Please take it back.
Yes, sir.
Items 58 and 59.
May I please the last? My lord, the 58 is, my lord, I got returned on 31st July 23, but the imping order has been passed on 25 at page 63, my lord. After my retirement, lordship can see last paragraph, lordship will see that will be revealed. Therefore, the governor of Assam is pleased to impose penalty withholding one increment with cumulative effect upon D.O. Srimati so-and-so. The departmental proceeding drawn up so-and-so by order dated 14/10/20. And I got retirement, my lord. When the cumulative effect will, increment will come, my lord. There is a question does not arise for increment, my lord. After my retirement, then
We seek some time, some consultation is going on. We seek some time to respond. And the other case, my lord, she is praying for provision pension which has been released.
No, my lord, only 1 month.
No, my lord, it has been accorded approval. It will come to them. I have the DDO numbers also.
No, my lord, I have received on the 21st, my lord, 43,300 only. No speaking order, it is
We'll record.
area or nothing.
He says that it is under process, we'll record.
Yes.
Lordship will kindly have a look.
In item number.
Or I may be permitted to access.
WPC 3723, counsel for the petitioner. Counsel for the respondent, Mr. D. Gugoi, submits that instructions are awaited. We would like to renew this prayer for further time.
That, my lord, imping order can be stayed, my lord.
Which order?
That first writ petition, page 63.
What benefit do we get?
My lord, that is, my lord, what order they have
It
given.
cannot be implemented.
They cannot be, my lord.
So what effect does it have of giving a stay?
My lord, in the name of DP, my lord, my pensionary benefits have got withheld.
You are asking stay of what?
That impugn order, my lord.
So even without that impugn order.
It has no
your
legal
DP
force.
Your DP
No
doesn't
legal
get stayed automatically. DP has been concluded.
concluded. And when, my lord, the
So
cumulative
stay
effect.
of the order is not going to lighten your anxiety.
Yes, yes, my lord, that will.
Insofar as the second writ petition is concerned, it is submitted that provisional pension with DNS allowance and medical allowance as admissible was sanctioned and accorded, has been accorded sanction with effect from 1/8/2023 in favor of the writ petitioner. By order dated 9/10/2025. The provisional pension has been shown to be restricted to a maximum period of 6 months from the date of retirement. It is the counsel for the petitioner on the other end submits that the entire amount has not yet been received.
Only, my lord, 41 or 46.
I have placed a chart, man, with the DDO numbers.
DDOs have been issued.
Yes, my lord, there's a chart, my lord. The set of documents I placed, there's a chart.
These amounts are to be released.
Yes.
Yet,
how soon?
This will be released, my lord, because once DDOs are issued, there's a.
Mr. Gogoi on the other hand submits that all steps are being taken towards release of the provisional pension as per the list submitted by the department, a copy of which he has placed before the court. List these matters again after 2 weeks.
any day by first week, my lord, I am without anything.
First week.
First
not-
week, second week, as
Second,
lordship
later,
convenient, my lord.
17th.
Lordship.
There's where and being fine, my lord.
Whatever instruction they have supplied, my lord, be kept as a part of the record, my lord.
Yes, we have kept it.
Lordship.
Obviously.
59, I'm for Accountant General.
MS Adar Sokia for Accountant General in item 59. Mr. A. Chakraborty for
6 response, 6 item number 58.
respondent 6 in item
58.
58.
Obviously.
Published.
Item 51.
Lordship, unable to obtain an instruction, Lordship, petitioner failed to serve extra copy, Lord.
No, we have already served, my lord. On 25th of September, I have the receipt copy.
Somebody else received it on your behalf.
Sorry, Lordship.
My lord, here, my lord, the case is in short, my lord.
Let him obtain the instruction.
A short date may be given, my lord, because pensionary benefit has been refused on some.
P. Chakraborty appears for the petitioner. And Mr. A. Chakraborty, learned Brahmin advocate, representing the state, prays for further time to complete the instruction. Please, again, after 2 weeks.
Obliged, Lordship.
MS Avar Sophia for
Right.
My
respondent.
date may be fixed, my lord.
17th.
17th of November. I'm obliged.
Obliged.
62.
May I please, your lordship? Lordship, matter pertains to non-payment of pension, my lord. Respondent number 3, 4, and 5 and file affidavit, my lord. I want to file reply affidavit on that. Lordship, may allow me kindly 1 week time, my lord. Matter may come upon 13, my lord.
Mr.
S.A.B. Khabir, my lord.
S.A.B.
Khabir.
Khabir, learned counsel, appears for the petitioner. Counsel for the petitioner prays for a week's time to file the rejoinder affidavit to the affidavit filed by the respondent. Mr. P.J. Fupan, learned counsel, represents the Guwahati University. Mr. Subrod Miya for
Respondent one.
Just appears for respondent number one. As prayed for by the counsel for the petitioner, is this matter after 1 week.
Briefly applies most of it.
For hearing item 54.
One brief note, you are prepared. What is this?
That's it. During the proceeding, Lordship, I request this honorable court that I did not receive some response against my submission.
Are you aware of the last order which was
Yes,
passed?
yes, Lordship.
So you were asked to pass, prepare a brief note.
Lordship, during the proceeding, I pray to this honorable court that I did not receive some response against my submission, Lordship. After getting the response only, I can submit, prepare a short note, Lordship. Then this honorable,
No, this court has said that pleadings have exceeded 1800 pages. So in order to effectively give you a hearing, prepare a short note.
Lordship, this note is sufficient if.
Which note?
Next are 9C and 9D, Lordship. And 9C consists of the details of justification against the.
No, the brief note will indicate your basic grievances, why you have come before the court, what has happened, what orders were passed, relevant orders, everything. It's a brief note to understand what has happened. Well, 9C, 9D, these are annexures.
I recently prepared, Lordship, based upon this last order.
You're challenging your dismissal order.
Yes, Lordship.
Oh.
In 90, with respect to my prayers, Lordship.
I have not got anything 9D.
Lordship, this honorable court did not allow me to serve a copy. If this allow.
We allow, you serve. You serve copies, let him go through, then you respond. Have you prepared a short note?
I have prepared my list of dates.
Not list of dates, short note in terms of the earlier order.
I'll prepare a
Brief note. Brief note if you have, prepare it, serve it, exchange it. You must give some time to the court also to understand the complexities of the matter.
Yes, Lordship. If I get actually response from the submission that I stipulated in 90, then I can prepare a short note within a pages of 10 pages only, Lordship.
What is 9D?
90, the issue against which I am not getting any response, any information and document, Lordship. These are the initial issue. If required, I will submit some more issue, but these are the initial issue against which I am not getting any required response, any information and document.
Let them file it, let us see. Let them file the note. Let them prepare the note in terms of the last order of the court. Order of this court as per the last order. Once it comes, we will see if any further details are required from them. That will direct them.
And Lordship, in previous order, it was 22/09/2025. This honorable court strictly ordered that to give the details against my pending dues. But Lordship, they submit a affidavit I dated 26/09/25, but they did not.
Mr. Deka, please get a compilation of the entire matter, not only your submissions. What is the issue here? Give a compilation. What is their case? What is your case? What orders relevant for these purposes have been passed by the court? Good.
Regarding the merits, my lord, as
merits,
this court has not entered into, my lord.
What
The
else is
order,
there?
the orders are regarding some payments which he claims has not
But
been made.
his entire voluminous petition is about his challenge to his proceedings.
No, I'm not on that, my lord. I'll make a summary of my submissions as well as his case, my lord. But because I thought, my lord, the list of dates would be good enough because I'll be relying on such only the departmental proceeding, my lord.
So that's all right, but considering that he is a petitioner in person, we require assistance of
Definitely.
the council.
Ma'am.
You prepare, serve it on him, give it to us. It is possible that he may not agree with the entire gist of which you prepare, but at least we'll have something to proceed.
My lord.
Otherwise, this volume will keep on growing.
Regarding pending dues, also they are not giving required information and document. Even though this honorable court.
That has been their stand since the last several dates that there are no further dues to be given.
But they did not give required information. They are just randomly and given inconsistent statement.
So your entire case is your challenge to the proceedings, departmental proceedings, termination order.
Yes, sir.
So we want to hear that if supposing you succeed, if the court allows your petition, directs them to be reinstated, then you are entitled to all dues.
For that, actually, I need some information to defend myself. They did not provide those information. They did not give the document. That is why everything was tabulated in Annexure 90.
Which specific documents you want?
That are tabulated in 90, Annexure 90. That I already just served to the Learned Council.
Tabulated where?
Annexure 90, Lordship.
We are going through 90. Any page numbers?
Lordship, all are from serial number 1 to serial number 71, Lordship.
What is that number 2 that you want? Serial number 2?
In with respect to the serial number 1, Lordship.
No, serial 2.
Lordship, the respondent has failed to provide any provision of document that authorize any person or respondent to act contrary to the law, emphasizing incessant.
Do you have the provision of the rules? Do you have the rules, access to the rules?
No, Lordship, that is, it is related to serial number 1, Lordship. They did not give me the information. So, why they did not give me the information?
What information you want?
The details information that I mentioned in my repetition as well as my subsequent affidavit, that are some of them important information are issues are tabulated here, Lordship.
No, you are referring to the same submissions. You point out, quantify it 1, 2, 3, 4, X, Y, Z. These are the information I want.
Yes, Lordship, kindly refer to serial number 15. These are yes, sir, related to recently address the issue of my pending dues. Kindly refer to serial number 15. The respondent also failed to specify or clarify when it was decided and confirmed that I was absent from duty.
This is the subject matter of the inquiry report.
So, Lordship, when with respect to not releasing salary,
You're Mr. Bora.
Yes, Lordship.
You're Mr. Bora.
Yes, Lordship.
So when the court will examine the correctness of the proceedings, disciplinary orders passed, etc., we'll examine whether it was there or not. If they have not given you, we'll examine that.
If it is a final, it will be a final hearing that it will be without getting information, it will be difficult for me to defend. Lordship, because they are not giving information. Lordship, can you refer to serial number 30?
Mr. Bora, we don't operate as per your requirements. There is a procedure, there is a mechanism by which the courts operate. You have come to the court asking for relief. We want to look into your papers to understand whether the relief that you have prayed for, you are entitled to it or not, and if yes, to what extent. For that, it is necessary for the court to understand what is your grievance. What information they have not given, how much information they have decided not to give you are issues, we'll examine it. So therefore, you make a gist of your prayers before the court. What exactly are you asking? For what purpose are you asking the orders from the court? The gist is necessary because as per coordinate bench order, the pleadings have gone beyond 1800 pages. So
Lordship, recently, Lordship, regarding the pending dues, Lordship, I only submitted two.
you wanted, is your case relating only to the pending dues?
No, I just given an example, Lordship.
No, no.
Regarding some
You
pending dues,
answered
I
the
just.
question, you answered the question of the court. Are you before the court only seeking specific directions that certain pending dues are to be released?
Lordship,
Or is it a part of the bigger prayer before the court that your termination is illegal?
Yes, Lordship, with respect to the pending dues, if I get information, then only I subsequently defend my other claim, Lordship. Because if I'm not getting information, the initial information, then how can I defend my
You
other
have
claim?
already filed, we don't know if your case does not contain merit, we'll dismiss it.
Lordship, they mentioned that the salary as well as some, Lordship, kindly at least they recently released the gratuity amount. Kindly refer to the serial number 32. The respondent failed to provide the details and particular relating to and on the basis of which they released the gratuity amount. They just mentioned that this amount is released, but they did not give the details also. Accordingly, Lordship, there are some other issues. Like they mentioned that the rank of the respondent 6 have the required authority for to act as a discipline authority, but they did not mention his rank and position. By which document they claim that his rank and position is equivalent to the discipline authority. They did not get without going through that kind of information. How can I defend that he is not competent to? Respondent 6 is not competent to act as a discipline authority. They mentioned that he has the required rank as per designation of GM. In one document, they mentioned that as per the designation of GM, he has required rank. And another document, another pages, they mentioned that as per the designation of CGM, he has the required rank. This kind of contradictory.
Right, Mr. Bora, petitioner in person.
That is why.
And Mr. N. Deka.
2 and 3.
Appearing for respondents 2 and 3. Mr. H is asked for
4, 5 and 6.
4, 5 and 6. The writ petition essentially has been filed by the petitioner in person, who has approached this court, putting a challenge to his termination order from the respondent. Company where petitioner was employed. Stop. Besides the specific challenge made to the termination order, there are other ancillary challenges made, seeking directions for furnishing of various information, as well as claim monetary or financial claims, which the petitioner in person submits that the amount, although payable, has not been released by the respondent authority. Stop. On earlier dates, the petitioner in person was offered counsel to be appointed by the court for assistance. However, the same has been categorically refused to be availed of. Stop. Be it as it may, the coordinate bench by order dated 26/9/2025 has directed both parties to file a brief note on the submissions made, on the submissions of the parties. A brief note, not exceeding 15-20 pages on the submissions required to be made before commencement of hearing. This court, considering the voluminous pleadings and also keeping in view the various issues raised by Mr. Bora, petitioner in person, considers it appropriate to appoint an amicus to assist the court. This decision has been taken by the court so that the reliefs prayed for can be properly, the reliefs prayed for and the prayers made by the petitioner in person vis-a-vis the objections raised by the respondents can be placed before the court so that the cause of justice is served. Let this matter be listed again on Friday. Friday.
Yes, can you mention that?
On
I had already
on the next date, the court will appoint an amicus.
Lordship, kindly,
Yes,
I have submitted the next 9C and 9D already served to them. Can you mention?
Petitioner has submitted certain compilations which are marked as annexures 9C and 9D, which are kept in the case record, and copies thereof have also been served on the respondent authorities. Stop. List on Friday. You are entitled to make a mention at in the morning. It is for appointment of a amicus curiae.
Only for that purpose.
We'll appoint. You make a mention. If at 10:30 we can do it, we'll do it. Otherwise, anytime soon thereafter.
All right.
Finding item 42.
Yes, Mr. Bonik, what is to be done?
My lord, so far as our appointments are concerned, that we had argued, long back. And we are
But there are
continuing to
no-
regularize.
Do you recollect signing any register at the time of Viva?
That I have to obtain the instructions because I'm told, my friend had said that while on one hand they say the register is there and the other hand they say no, the marks were recorded but not in register. But these are factual things when I do not have the instruction at the moment.
Have you indicated anywhere, has it indicated anywhere in the affidavit that there was only one register?
No, register I have not said, but my lord, I have said I have put my signature.
Of course, signature can be put anywhere. I'm not.
No,
No, in the
register maintained for
Vaibhavosi.
Vaibhavosi.
Yes, ma'am.
Where have you stated that?
Yes, ma'am. Page 91, my lord. From below 1, 2, 3, 4, 5, 6, 7. From below 7th line, ma'am. It is also stated by the petitioner that while putting his signature for the Vaibhavosi test in the attendance register meant for OBC candidate. the
Sorry,
peti-
90?
Page 91, my lord. Serial
91.
Inner page 4.
Reply.
Reply. Reply.
The reply is only sound. Looks about your name.
From below 4. 5, 6, 7. It is also stated.
91.
It is.
Also stated by
uh,
that while putting his signature for the vivacy test in the attendance register meant for the OPC candidate, the petitioner did not found the roll number 30 and respondent number 4 in the attendance register, meaning thereby the respondent number is not a so and so. Therefore, the authorities may direct to produce the said attendance register.
And is there any reply? Counter
No,
affidavit?
no.
There is an averment here, Mr. Bordolo.
Lordship.
So you file an affidavit. If they have this thing is there, it is there. It is not there. We'll see what orders we'll have to pass. But put your department to notice that they are filing by way of an affidavit.
Yes.
Yes.
We would also like to file an affidavit because it's on a factual stand they are taking.
File it.
Because and one thing, madam,
File
since in the High Court practice, when the petitioner files a reply to an affidavit filed by the respondent, the private respondents are not put to notice. If practically today I have come to learn that the statement is there.
High
Practically,
Court rule says that.
High Court rule says that we do not object in the course of the business.
No, High Court rule says that all.
We are not
pleadings-
served with that. Let me put it
pleadings
that
must
way.
be served.
We have not been served. We have put to notice right now across.
We have not
So I
been- we have
reserve
not
my right to
served.
reply to that.
No, madam.
How?
We have, this was in reply to my friends.
Mr. Counsel,
I will serve him.
it comes to the same file.
Yes.
Unless the council knows that there is a pleading on which you are making your submission, how will he rebut your submission?
I'll submit, serve him a copy.
Please check up the High Court rules. There's a specific provision.
Thereafter, I'll file a reply. That's not.
All right, copies of the, what is this additional affidavit?
No, it is
Affidavit in reply,
reply, madam.
filed by the writ petitioner, will be served on the council appearing for the private respondents. Stop in the said affidavit, at
Para 6, madam.
para 6. Page 4, there is an averment. There is a specific averment made by the writ petitioner that he had put his signature for the Viva Voce test in the attendance register meant for the OBC candidates. Stop. The para, during the course of the hearing, the court directed the counsel for the cooperation department to produce the relevant registers from the department. Stop today when the matter, today the learned standing counsel has placed before the court a copy of the register which he submits is the register maintained for signatures of candidates at the time of written examination. Stop. He further submits that there is no affidavit, there is no register maintained for Viva Voce test. Stop. Para this submission appears to be contrary to the averment made in the affidavit filed by the writ petitioner. Stop. Accordingly, let the department also file an affidavit as to whether the any separate registers are maintained for the Viva Voce test as stated by the writ petitioner. Stop. The private respondents are also at liberty to file any